May I be permitted? May I be permitted to mention a matter, my lord? Lordship kindly give me leave, Lord, to file memorandum of appeal without the certified copy of the order. The order was passed, Lord, on 20th of June.
When did you apply for the certified?
My lord, today I will apply, my lord. My lord, this is very urgent matter. My lord, in course of the day, my lord, I can show. My lord, Lordship kindly, this is very urgent matter. This is regarding higher pension, my lord. My lord, the portal is going to be.
Mr. Prasad, call the list.
My lord, today, my lord, I will, my lord, kindly within two.
Mr. Prasad, you have not applied for certified copy.
My lord, yesterday we have not decided. My lord, then we are 2 p.m. Lordship. After my lord, Lordship, this is very urgent.
Don't insist, Mr. Prasad. We have rejected your prayer.
Then I will come, my lord, kindly at 2 p.m. My lord, I will come.
Not at 2 p.m. You apply.
Yes, I am applying.
Immediately a certified copy are made available. This has now become a fashion. Then take appropriate steps, exclude the process of obtaining certified copy, apply for amendment.
I'm sorry, my lord, but my lord, this is so urgent. My lord, I will come back at 2 o'clock.
No, not 2. Not 2. Yes.
Item 2, my lord. I appear for the respondent, my lord.
May I please your lordship? Lord, I appear for the appellant WBC DCL lordship.
Yes, Mr. Naik.
Issue is very short and it was discussed also earlier because the petitioner, my lord.
You have complied with the order. There nothing remains to be decided.
My lord, that's the issue only. Now, my lord, we are, my lord, basically agreed because the outstanding dues was not recovered. It's not a case of restoration; it's a case of new connection. We have given new connection. Now, my lord, our point is that we are entitled to WBCDCL is entitled to recover the amount. Now, whether restoration is given,
Record, it has become infructuous.
no, my lord,
It's
only
not that your point is closed for further adjudication.
no, my lord, only one short submission, Lord, kindly. But on the same issue, my lord, Supreme Court has said, my lord.
We are not on Supreme Court. We are on the facts of this case.
My lord, yes, the fact is this, in short, that there is outstanding dues and line is remaining disconnected in the premises for a long.
Decided. That issue, the present appeal has been.
Issue will be decided. If it is infructuous, issue will not be decided. It is
not. Another claim, file, take appropriation. The present appeal.
But kindly consider this judgment only, my lord, once.
The present appeal has been preferred, challenging an order dated 15 June 2016. Passed in a writ petition being WP 8026W of 2016. Stop. Mr. Das, you are Mr. Bhattacharya.
Mr. Das. Mr. Das.
Mr. Das, learned advocate appearing for the respondent number 1, submits.
On the basis of the
That during pendency of the appeal, stop. WBACDCL has complied with the order impugned and had granted new electricity connection in favor of the respondent number 1. Such fact has not been disputed by Mr. Naik, learned advocate appearing for the appellants.
On instruction, lordship.
Such fact has yes, such fact has not been disputed by Mr. Naik, learned advocate appearing for the appellants. Stop. In view thereof, the appeal and the connected application are dismissed. There shall, however, be no order as for certain settlement.
Lord, only kindly grant us liberty so that we can have option to recover the amount if law permits so. Otherwise.
Yes, call the next.
But on the regarding restoration, we have got the Milord instruction also. Let it be kept with the record. Only one line, Milord.
Let the has not has not been disputed by Mr. Naik.
Client restored.
Let the written instruction. Where is it?
I've given it.
my lord, my lord.
Let the written instruction, as produced, be kept on record.
My lord, I am appearing with Mr. Devjit Mukherjee lordship also.
But I am in virtual mode, my lord.
No, no.
Where are you?
My lord, only difficulty is that, my lord, I am coming to your lordship's court, my lord, that is.
Who is appearing
Devjit Mukherjee.
along with you?
Yes. Devjit Mukherjee and my lord. Devjit Mukherjee.
Such let the written instruction, as produced, be kept. Yes, next.
Well, one line that liberty has been given, my lord, that may be given, my lord. We can also go for suit and other option, lordship.
That option is open to you always.
Obliged, lord.
Lord, there is a direction to file a report, Lord. Lord, kindly excuse, Lord, me, Lord. Kindly skip, Lord, first two lines. Lord, since, Lord, they have seen the orders and your lordships names were appearing, Lord. So accordingly, they have kindly skip, Lord, those two lines. And thereafter, your lordship would kindly. The lordship asks for the, Lord, the steps taken by them and, Lord, the
Yes, madam. What do you say?
the able-bodied man, Lord, the school teacher, Lord, he was deserted from family and developed, Lord.
Lordship, in the last
Madam, please.
occasion, you have asked me to seek instruction from the petitioner that any steps had been taken against her or any monetary relief she is getting from the school. Your Lordship, no steps has been taken against her and no financial help is she's getting from the school.
They made an endeavor, madam. What can be done further? You are his
Wife.
You are his wife. Do you have any children?
Yes, one son who is physically handicapped, Your Lordship.
Mr. Ahmed, any scope
Your Lordship, kindly,
and handicap?
Lord, I appreciate, Lord. Kindly keep the matter pending for some time, Lord, since, Lord, the SP has intervened and he has filed a report. And there is a seat form, Lord, to recovery. So, Lord, kindly give us some more time and let me see and talk to the SP personally whether this could be done or not. But the difficulty is, Lord, the difficulty is in this situation, Lord, the people conceals themselves.
But you must also make an endeavor to give any further details you have to the police. How will the judge, since the habeas corpus petition has been kept pending, They are trying, but the thing is, you also have to give some footage. What was your matrimonial? Did you have any dispute?
No, Your Lordship, no
That's what
matrimonial.
they are saying.
But there was no matrimonial
Yes,
dispute.
that is there.
She was having the paragraph.
She has disclosed to the close friends of at his workplace. They have been examined, Lord, their statement has been recorded, and
You are Reba Das. Reba
no,
Das is the
Reba
petitioner.
Das is a lady.
Reba Das is another Aparna Nandi.
Yes, I am Aparna Nandi.
Paragraph 9 to the-
Ashish had some relationship with Reba at paragraph 9.
So have you interrogated that
Yes,
lady?
yes. The lady was examined and it was unearthed that before his disappearance, Ashish Nandi was mentally exhausted and he went to her to get company. There is no wrongful restraint.
Yes, the whereabouts of Ribadar.
Yes, we have got the whereabouts of Reba Das. We examined her.
We examined her.
Yes, Your Lordship would kindly see paragraph 9. The lady was examined and it was unearthed that before his disappearance, Ashish Nandi was mentally exhausted and he went to her to get company. Difficulty is, Lord, there is no operation of banking issue. There is mobile we are unable to, he has thrown it out or something has happened. So there is no clue that if a able-bodied man conceals himself, it's very difficult, Lord, to get hold of him.
No, her,
But
did
we need to
you
wait, Lord, in certain cases, Lord, we have seen.
have registered a registered an proceeding? You have not?
Yes, Lord, Vardhaman PS case number 810 of 2021, dated 10/8/2021.
Now,
under
what
six-
is the outcome of this
We are investigating it, Lord. We are investigating it. But as I said, it's difficult, Lord. If somebody conceals himself, it's very difficult to get hold of him.
But this is an exceptional case.
Lord,
The
he is-
lady
Lord-
is having his salary must have been stopped.
Yes,
Must have been stopped. She has an handicapped child. Where will she? Pursuant to the earlier order passed by this court, Mr. Ahmed, learned advocate appearing for the state, has placed before us a report of the Superintendent of Police, Purbo Bardhaman. Stop. Let the same be kept on record. It appears from the said report that appears from the said report that investigation is still continuing. Investigation is still continuing. Stop. The Miss Tal and the advocate appearing for the petitioner submits that the petitioner submits that that her husband, namely Ashish Nandi,
Ashish Nandi.
was working as an assistant teacher. Was working as an assistant teacher in which school?
Just a minute.
in Lord, Horish Chowk High School, Khanakul, Hugli.
Where did you get it?
Paragraph 10 of the report.
Paragraph 10.
Top, Lord. A thorough inquiry was done at the workplace of the missing person at Horish Chowk High School, Khanakul, Hugli. Page 4, Lord.
At as an assistant teacher at Horish Chowk High School, Khanakul, Hugli. Stop. As her husband is still missing, the school, his salary is still missing. His salary has already been stopped by the school authorities. Stop. She is suffering extreme financial, the petitioner is suffering extreme financial hardship, and and it has become impossible for her Her salary has already been stopped by the school authorities. And the petitioner and her handicapped son is suffering from extreme financial distress. Stuff. Considering such facts, earlier direction was issued by a coordinate bench of this court. In view of such fact and as investigation is still continuing, we direct the police authorities, we direct the members of the SIT to take all possible steps and to make a sincere endeavor to recover the petitioner's husband. Stop. List the matter for further consideration on 26th July. Stop. On 26th July.
Can it be
The
little,
superintending, the
can it be little after,
superintendent of
Lord?
police
Can it be little after, Lord?
on 8th August, the
Obliged.
superintendent of police Purbo Bardhaman is directed to file a further report on the returnable date as regards the further steps taken by
Obliged.
in course of investigation.
Sorry.
Directed to file a report on the returnable date detailing the further steps taken. Stop.
This is the second or third occasion the petitioner is not appearing.
Cousin brother of Radhika, married lady.
The married lady, my lord, disappeared from the matrimonial house.
Any case registered?
My lord, case has been registered. My lord, investigation is on. This time, my lord, the case was registered under section 365, 370 of the IPC, and the investigation is on. They have taken steps, my lord.
Yes, yes, yes. Is the cousin brother of Radhika. Only is a party.
Initially, the writ petitioner was also not cooperating with the investigating officer. My lord, that is reflected from the report. That there was a constant
Trafficking charge is there, no?
My lord?
Trafficking charge is
Yes, trafficking charge is there. So, my lord, it kindly dispose of the writ petition, directing, my lord, the investigating officers to come to a logical conclusion, my lord, as soon as possible. They have lost interest, hopefully. And the FIR was almost, my lord, after almost after 8 months.
Records reveal that no one appeared on behalf of the petitioner when the matter was records reveal that no one appeared on behalf of the petitioner when the matter was last taken up for hearing on 9 June 2023. Stop. Today also no one appears on behalf of the petitioner and no accommodation has been sought for, though Mr. Ahmed Learned Advocate appearing for the state is present. In view thereof, the writ petition being such and such is dismissed for default. Yes.
Obliged. চারটাতে আছে না? নেই তো? পাঁচে কি আছে? পাঁচে কি আছে? There's a direction to file affidavit, blood, by the earlier bench, blood. So there is a affidavit, blood. ফোন করিস নি কেন? ঘরের ঘরে লিস্ট আসছে ওইখানেই হারিয়ে গেছিল।
Here is the dollar absconding. No one records reveal that no one appeared on behalf. ওই আগের অর্ডারটা দিয়ে দেবে তো মিস্টার স্টপ 9 June 9 June তারপর though Mr. Ahmed Learned Advocate is present, stop. Let the
report in the form of affidavit, blood. Long back, blood, it was directed. We are prepared.
Let the report, as filed by Mr. Ahmed be kept on record.
নেই তো কিছু।
No one appears on behalf of the petitioner. Stop. Mr. Ahmed Learned Advocate appearing for the report. Appearing for the state files the report as called for earlier. Stop. Let the same be kept on as called for earlier. Stop. Let the same be kept on record. Stop. Records reveal that no one appeared on behalf of the petitioner when the matter was last taken up for hearing on 9 June 2023. Stop. Today also no one appears on behalf of the petitioner and no accommodation has been sought for. Stop. In view thereof, the habeas corpus petition being such and such is dismissed for default. ওই ওপরে ওই no one appears on behalf of the petitioner কেটে দাও, শুধু মিস্টার আহমেদ থেকে আরম্ভ করে দেবো। Yes, next.
Obliged, blood.
On appears on behalf of the petitioner and no accommodation has been sought for in view thereof. The writ petition being at is dismissed for.
My lord, and the petitioner's minor daughter was missing. My lord, habeas corpus filed. Thereafter, subsequently, she was recovered. My lord.
The learned advocate appearing for the petitioner submits that the learned advocate appearing for the petitioner submits that the petitioner's daughter who was missing, had already been recovered during pendency of the present pendency of the present application system. Next para, in view thereof, no further interference is called for in the present habeas corpus petition, and accordingly the same and the same is accordingly disposed.
Grateful, lord. Grateful, lord.
Yes. হচ্ছে এটা affirm করে দিয়েছে।
Lord, I believe, my lord, the writ file has come, but we have also prepared, my lord, extra copies of writ petitions for your lordship's consideration.
All right, when you place, we shall take a copy.
Well, now, my lord, the matter pertains to, my lord, regularization of some employees of a club, my lord, which is organized and run by a committee comprised of some employees of the Kolkata Port Trust. Well, the Kolkata Port Trust now, of course, my lord, the name has changed. Now it is the Shama Prasad Mukherjee Port. My lord, has come up in appeal, but against the order of the learned single judge. The learned single judge has confirmed the award passed by the Industrial Tribunal. Now, if your lordships may kindly have a look to, my lord, the order under appeal. It's at page 109 of the stay application. May I place this order for your lordship's consideration? The petitioners have assailed the award of the Central Government Industrial Tribunal, Kolkata, passed on 19th December 2019. Respondent numbers 3 to 15, who are the employees under the Kolkata Port Trust Club, Holdia, being the 16th respondent herein, applied before the Assistant Labour Commissioner for regularization of their services under the Holdia Dock Complex. Upon failure of conciliation, the matter was referred to the Industrial Tribunal, which decided the issue in favor of the respondent numbers 3 to 15 by the award impugned. It is contended on behalf of the petitioners that the Kolkata Port Trust Officers Club
was set up in 1987 and has its own existence and structure, as shall be evident from the constitution of the club. The members of the club consist of the officers of the KOPT, including retired officers as well as other officers of the state, central government or private public sector undertaking in Holdia, who are called associate members, and membership of the club is not coterminous with the employment with KOPT. The club generates its funds through several activities, including subscription of members, and also receives grant from the Kolkata Port Trust. The employees, including the 13 respondents, are recruited by the club. But this is very important, recruitment by the club. And under the administrative control of the club. Now, our case is that there is no administrative control. I will demonstrate that. The club administers administrative as well as financial control over the employees and cannot be linked with the activities of the KOPT. More so, since the membership of the club is not restricted to the employees of the KOPT only. Per contra, KOPT is governed by its regulations of 1985, which include central government rules for regular appointments. Such appointments are made in terms of the regulation by promotion, transfer of employees, or direct recruitment. Learned Counsel has taken this quote to paragraph 9 of the award, which enumerates guidelines for determination of the question of relationship of employer and employee as dealt with by the Honorable Supreme Court in Balwant Singh Saluja versus Air India, reported in 2013-15 SCC, page 85. Where the guidelines are as under. 1. Who appoints the workers? 2. Who pays the salary remuneration? 3. Who has the authority to dismiss? 4. Who can take disciplinary action? 5. Whether there is continuity of service. 6. Extent of control and supervision, and whether there exists complete control and supervision. These are the 6 guidelines which has been laid down by the Supreme Court to assess or ascertain as to who has the control. The appointment letters were issued in favor of the respondents by the club, and the notice of employment inviting application for temporary vacancies for the guest house was also issued by the club. Now, there is a guest house also. The bank statement, I'm sorry. Therefore, it is the club and not KOPT who appoints the workers' employees. The bank statement of the club indicates that remuneration of the employees' respondents is disbursed by the club. With regard to the authority to initiate disciplinary action against the employees, the appointing authority, being the club, has such entitlement. The guest house is admittedly under supervision and control of KOPT and not the club. It appears from the note sheet of the KOPT that for the management of the guest house, employment is made by the club in consultation with the finance division. HDC management provides additional grant to the club to meet the additional financial burden. HDC management does not take responsibility of recruitment. The deputy chairman of the KOPT, being the president of the officers club, takes decision in regard to the club. The KOPT only sets up a standard for appointment by the club and has no direct control over the same. It can at best be said that KOPT has secondary control over the club. In the award impugned, the tribunal has recorded that the deputy chairman of the HDC has not only approved the creation and filling up of posts, but also promotions to the club employees. But the office order of the CPT Officers Club indicates that a club assistant was proposed to be promoted to the post of senior club assistant by the club on the approval of the deputy chairman, who is also the president of the club. The employees are governed by the rules, regulations, laws, orders, notifications, and resolutions of the club as appears from the appointment letter. With regard to the financial control, the KOPT sanctions additional grant to the club to meet the salary requirement of the employees of the club and other expenses under corporate social responsibility, and has no financial control over the club. Resolution regarding uniform of the employees is also taken by the club, subject to approval of the KOPT. The KOPT has no statutory obligation to start the club, and it was established only for recreational purposes. The fact that the club is not a registered entity does not ipso facto bring it under the control and management of the KOPT. The management of the club is controlled and governed by the club itself, and the deputy chairman of the KOPT grants approval in some cases in the capacity of the president of the club. Though there may be overlapping decisions taken by the KOPT and the club, that does not create an employer-employee relationship between the two concerns. The KOPT has no direct control over the club, and it can at best be said to have a supervisory control. Distinguishing the judgments referred to by the employee respondents, Learned Counsel has submitted that judgments deal with workers of statutory content and have no manner of application in the present case. Learned Counsel has placed reliance on the authorities in Balwant Singh, Saluja, etc. Learned Counsel for the 16th respondent, which is the Kolkata Port Trust Officers Club, Holdia, has taken this court to the appointment letters issued by the club and submitted that the appointment to various posts of the club is offered by the club itself, which is independent of the Port Trust. The club is run and managed by its managing committee, executive committee, and is governed by its own bylaws. Membership of the club is not restricted to the petitioners and is open to other government, public sector, and private organizations. The administration and function of the club are independent of the KOPT. Financial control of the club is exercised by the club. For example, club sanctions and grants loan to employees on their application. Disciplinary action is also taken by the club against erring employees, thereby indicating that the club has administrative control over its employees. In the reference made before the Industrial Tribunal, the respondents' employees have been wrongly referred to as employees of the guest house, and there is no whisper about the club therein. Therefore, the very basis on which the award was granted is erroneous. In addition to the submission made by him, Learned Counsel has adopted the submissions made on behalf of the petitioners. Raising vehement objection to the contention of the petitioner and the respondent number 16, Learned Counsel for the respondent numbers 3 to 15, that is the employees, has canvassed his arguments as under. The club is not registered and therefore has no legal entity. It is not in dispute that the club is situated on the land of KOPT. The workmen filed a writ petition earlier for absorption of their services by the petitioners, and the Honorable Court, by orders passed on so and so, gave direction for absorption of the employees within a stipulated time frame. The matter was dealt with by the general manager instead of the deputy chairman of KOPT, who rejected the representations of the workmen, against which the workmen filed another writ petition and a contempt application, and the matter was relegated to the Industrial Tribunal.
These workmen, these
These workmen. The note sheet of the KOPT administrative department demonstrate that furniture of the guest house and appointment of employees therein were provided by KOPT, and additional grant was given to the club to meet the financial burden of appointment of employees by the club. The documents reveal that the club is not an independent identity. I'm sorry.
যখন another petition করে ফেললো
For implementation. This was for the implementation of the earlier. Yes, Mr. Dutt.
The note sheet, para 17. The note sheet of the KOPT administrative department demonstrate that furniture of the guest house and appointment of employees therein were provided by KOPT, and additional grant was given to the club to meet the financial burden of appointment of employees by the club. The documents reveal that the club is not an independent identity and acts on behalf of the principal, being the HDC. The signatories of all the documents relating to the club are representatives of the HDC and not the club. Administrative approval with regard to additional grant is accorded by the HDC, such approval being given in the capacity of the deputy chairman and not the ex officio president of the club. Issues like
salary of the employees.
salary of the employees and uniform of the workers are approved by the KOPT, and the audit report of the petitioners demonstrate that financial control of the club lies with the KOPT. Creation and filling up of additional manpower of the club for running the guest house is approved by the deputy chairman of KOPT. The HDC has its say over every matter of the club, however petty may be. Learned Counsel has drawn the attention of the court to the inspection report of the accounts of the manager administration guest house for the period, and submitted that the reports say that accommodation charges calculated by the club from the boarders from April 1999 to October 2000 was deposited by the club to the HDC after a period of 19 months. Also, the charges to be borne by the KOPT and the club separately could not be ascertained. Therefore, the club has no separate entity and is part of the KOPT. The application for regularization of the employees of the club was made before the KOPT. The guest house staff wrote to the deputy chairman for regularization of their service and submitted that the guest house staff of Mumbai, Chennai, Cochin, etc. have been treated as regular port trust employees. In reply to the said letter, the HDC has undertaken to abide by the order of the High Court. Upon consideration of the evidence placed before the tribunal passed a reasoned order. The evidence furnished before the tribunal cannot be reappreciated by the writ court, and factual aspects laid down therein cannot be reopened. Learned Counsel has distinguished the judgments relied upon by the petitioners and has submitted that they are not applicable in the facts of the present case. Learned Counsel has relied upon the authorities in so-and-so, Chennai Port Trust, and the other judgments. Heard learned counsels for the parties and considered the materials on record. Responding to a reference made by the Government of India, Ministry of Labour under Section 10(1)(d) and 2(a) of the Industrial Disputes Act, to the Central Government Industrial Tribunal for adjudication whether the action of the management of the Haldia Dock complex in not absorbing permanently the service of S.N. Das, Ajay Mal, and 11 others employed in Haldia Dock complex guest house is justified, and if not, to what relief the concerned 13 workmen are entitled. The tribunal, by an order passed on 19th December, held that the club is under the control of the Haldia Dock complex both financially and administratively, and the workmen are employees of the HDC and are entitled to be treated as regular employees of the management of HDC. Learned Counsel for the respondents has placed reliance on the authority in the state of Karnataka, wherein the Honorable Supreme Court has observed that the power of judicial review is not an appeal from a decision but a review of the matter of the manner in which the decision is made. Interference with the decision while exercising jurisdiction under Article 226 is permitted when there is violation of the principles of natural justice or statutory regulation, or if the decision is vitiated by considerations extraneous to the evidence and merits of the case, or if the conclusion arrived at by the authority on the face of it so wholly arbitrary or capricious that no reasonable person could have arrived at such a conclusion. Such observation of the Supreme Court is the guiding factor in dealing with the present case. While dealing with the question of employer-employee relationship between the petitioners and the respondent numbers 3 to 15, the tribunal has relied upon certain parameters to be taken into consideration as declared by the Supreme Court in the authority of Balwant Singh Saluja and another supra as under. Well, these are the 6 points. Then para 25. It is not in dispute that the guest house is under the direct and complete supervision and control of HDC, and the workers, including the respondents, have an overlapping duties in the guest house as well as the club. The guest house is constructed on the floors of above the club on land admittedly owned by HDC. Each decision with regard to quality and norms of furniture fittings, charges for occupation of the guest house, management of the guest house, appointment of personnel and booking accommodation are under the control and administrative office of HDC, which entrusted the officers club to employ personnel whose scale of pay would be fixed in consultation with the P&IR and Finance Department, and the additional burden of such employment would be borne by the HDC. The notices of appointment and appointment letters were accordingly issued by the club as agents representatives of the HDC. Approval of creation and filling up of additional posts of the club for running the guest house was given by the deputy chairman of the KOPT on behalf of the CPT and not in the capacity of the president of the club. The appointment letters demonstrate that the appointments were initially temporary for a period of 1 year or such extended period as may be decided by the executive committee of the club. Since the respondents are still in service, it can be inferred that they are in continuous service. The acceptance of the offer of employment made by the employees was explained to the employees by the administrative office of the HDC. Though the appointment letters indicate that the employees are bound by the rules, regulations, bylaws, orders, notifications, and resolutions of the club and the guest house are manned by employees who are similarly placed. Since the guest house is under the control and supervision of the HDC, the obvious inference that can be drawn is that the employees of the guest house as well as the club are under the direct control and supervision of HDC. Administrative approval and permanent sanction in respect of additional grant to the club for payment of monthly salary to the staff engaged by the club for the guest house is granted by the HDC. Various bills submitted by the club regarding uniform of the employees and other expenditure are placed for approval before the deputy chairman of HDC. The club banks upon the HDC for fund, and the deputy chairman of the HDC approves enhancement of various allowances of the employees, and the rates of allowances are also fixed by the HDC. Expenditure of the club towards remuneration of the staff is reimbursed by the HDC upon application made by the club. Furniture, fixture, utensils, crockery, etc. are procured for the guest house, admittedly by the HDC. Service of the club, its employees, is utilized in several programs held at the HDC officers' guest house, and the club is requested to make necessary arrangements accordingly. Accommodation charges collected by the club from boarders are also deposited by the club to HDC. Administrative control is exercised by the HDC over the employees of the club, even in trivial matters like whereabout of a tablecloth. Each approval given by the deputy chairman of HDC is on behalf of the HDC and not in the capacity of the president of the club. The audit query sent by HDC to club demonstrate that every financial transaction of the club is subject to administrative approval of the HDC and is subject to audit by KOPT. The audit query says that the guest house of KOPT is run by the staff of the club, which maintains all the records of the guest house. The guest house in turn being controlled by HDC, it can be held that both the guest house and the club are controlled by HDC. Much has been spoken about the distinction between employees of statutory canteens and non-statutory canteens. The Honorable Supreme Court in the authority in Porimal Chandra Raha has clarified that no distinction can be made between employees of statutory canteens and non-statutory canteens, and workers engaged in both the canteens are railway employees and are entitled to be treated alike. The Honorable Court went on to hold that the employees of non-statutory canteens under the railway should be treated as regular employees subject to two conditions. A, that they are above the minimum and below the maximum age limit and medically fit as per the regulations of the corporation on the date of the filing of the writ petition, and B, that on the date of filing of the writ petition before the High Court and also during the pendency of the proceedings, they had put in a minimum of 3 years continuous service. The authority in Balwant Singh Saluja speaks about supervisory control and complete administrative control in determining the employer-employee relationship. The authority lays down two well-recognized tests to determine such relationship, which are: 1, whether the principal employer pays the salary instead of the contractor, and II, whether the principal employer controls and supervises the work of the employees. In the present case, the tribunal has answered both the questions in the affirmative upon consideration of the materials placed before it. Similar factual issues were raised in India Petrochemicals case. In that case, the workmen have been employed for long years and have continued to be employed. B, the wages of the workers have to be reimbursed by the principal employer. C, the premises, furniture, fixture, fuel, electricity, utensils, etc. have been provided for by the employer. D, the supervision and control is exercised by the employer. And E, the workmen have the protection of continuous employment in the establishment. On the basis of the above facts, the Honorable Court arrived at the opinion that the workmen were the workmen of the management. The fact situation in the present case being similar to that of the Indian Petrochemicals case, there is no reason why the respondents herein should not be granted the same benefit as in that case and treated as employees under the HDC. In the authority of the National Aluminium so and so, the Honorable Supreme Court has observed that there may be some element of control with NALCO because its officials were nominated to the managing committee of the schools only to ensure that the school runs smoothly and properly. This kind of remote control would not make NALCO the employer of these workers. This only shows that since NALCO is shouldering and meeting the financial deficits, it wants to ensure that the money is spent for the rightful purpose. Milord, pausing here for a moment, Milord. I would be, Milord, heavily relying upon this NALCO's case. Your Lordship will find that there is no further discussion on the remote control aspect in NALCO's case, where I'll place that judgment also, where Milord, NALCO had placed its officers in the managing committee of the school. Supreme Court held that just because few officers are placed in the managing committee of the school does not come under the direct control of NALCO. Your Lordship will not find that NALCO has been discussed by the Honorable Court, Milord, in the subsequent paragraph. This is only noting NALCO. Then para 34. In the case in hand, the nature and extent of administrative and financial control of the HDC over the club is direct and complete and cannot be said to be a mere supervisory control, thereby establishing the relationship of employer and employee between the two. The control demonstrated by the club is merely a veil between the respondents, between the respondents and the petitioners, which is required to be lifted. The decisions taken by the HDC with regard to the club do not merely overlap with that of the club, but are conclusive and binding on the club. Learned counsel for the respondents have drawn the attention of the court to the fact that the club not being registered under the West Bengal Societies Registration Act or under any other law, there was no separate legal, has no separate legal entity and is not entitled to frame any separate rules or bylaws. Just as the HDC is an entity of the KOPT, the guest house is also an entity of the KOPT. Per contra, learned counsel for the petitioners has submitted that the club being a non-statutory entity created for recreational purposes and having its own management, the same being an unregistered entity makes no difference. Be that as it may, the question laid down in the authority of Balwant Singh Saluja has been answered by way of elaborate discussion herein above. The notices of appointment and the appointment letters are issued by the club as agents representatives of HDC, and approval of creation and filling up of additional posts is given by the deputy chairman of CPT. Remuneration of the employees is shouldered by HDC. Though the documents on record do not indicate who has the authority to dismiss and take disciplinary action, it can be held that the appointing authority being the HDC is vested with such powers. It is pertinent to mention here that the 16th respondent has filed certain documents by way of an affidavit which demonstrate that the club took steps against the employees for misconduct on his part and sanctioned loan in favor of an employee. These documents were not placed before the tribunal by the 16th respondents despite having sufficient opportunity, and most of the documents were in fact prepared during the pendency of the writ petition. For the said reason, the documents relied upon by the 16th respondent cannot be taken into consideration by this court. Regarding continuity of service, since appointments were made as early as in 1989 and the employees are still in service, it can be inferred that they are in continuous service in the establishment. The extent of control and supervision of HDC has been discussed at length earlier, and it can be concluded without any iota of doubt that there exists a complete control and supervision of HDC KOPT over the club, which establishes employer-employee relationship between the petitioners and the employee respondent. One Parvati Das, who appears to be an erstwhile member of the Board of the Trustees and General Secretary of the Calcutta Port Shramik Union as on 8th December 91, has stated in a letter written to the Deputy Chairman on that date that the guest house staff attached to the Mumbai, Chennai, Cochin, etc. have been treated as regular port trust employees like the other employees of the respective ports. The respondents undoubtedly stand on the same footing and therefore cannot be deprived of the same relief. In dealing with the issue under reference, the tribunal has considered the material placed before it in its proper perspective and has arrived at the reasoned decision thereto. The order impugned does not suffer for violation of the principles of natural justice or statutory regulation and is not vitiated by by considerations extraneous to the evidence and merits of the case. The conclusion arrived at by the authority cannot, in the facts and circumstances of this case, be said to be so wholly arbitrary and capricious that no reasonable person could have arrived at such a conclusion. There being no fault lapse in the decision-making process of the tribunal, interference with the decision by the writ court while exercising jurisdiction under Article 226 is not warranted. In the light of the discussions above, this court is inclined to hold that the writ petition is devoid of merits. Now, my lord, two basic things, my lord, I need to, my lord, emphasize first. Before, my lord, taking your lordships and satisfying the 6 principles of Saluja's case inapplicable in our case, but I'll satisfy that. Now, my lord, 2 basic things, my lord, are required to be looked into. First is the KOPT is a body like all other ports constituted under the Major Port Trust Act. The ports, all the ports, they function under a board of trustees or the major ports. There are both major and minor ports. Kolkata Port Trust is a major port. Now, this board of trustees constitute of several persons, chairman, deputy chairman, XYZ. The terms and conditions of services of the employees, which includes the chairman, deputy chairman, and all other employees, my lord, are, my lord, framed by the board with the approval of the central government. I'll place those. The method of recruitment, appointment, disciplinary control, these are all, my lord, framed by statutory rules and guidelines, which are to be published in the official gazette and, my lord, with the approval of the central government. So, my lord, this is, my lord, the status of the employees of the major port, starting from the chairman to the employee of the lowest rank.
Yes.
This is, my lord, one of the major, my lord, fundamental limbs that requires your lordship's consideration. Second is, my lord, whether club employees or guest house employees can be compared with canteen employees.
Yes.
My lord, canteens, as your lordships know, can be statutory canteen or non-statutory canteen. But whether or not it is statutory or non-statutory, the purpose of setting up of canteens or providing canteens is to provide food to all the employees. This is very important. Whether somebody avails of the benefit or not, that is something different. But all canteens, statutory or non-statutory, they are meant for providing food to the employees of the organization, which is a 365-day affair, or if I may say, working days affair, because there are all establishments do not function for 365 days. Therefore, canteens are meant for the employees to be served with food throughout the year, whereas clubs are for recreational purposes,
Yes.
meant primarily for the members of the club. Maybe some retired employees are there, one or two outsiders may or may not be there.
Yes.
Now, my lord, members of the club ordinarily, though my lord, there are some people who go to the club every day, but ordinarily, my lord, there is no compulsory attendance in the club. And availing the club facilities is not akin to availing the canteen facilities.
Yes.
Milord, canteen facilities, wherever provided, Milord, are integrally connected with the provisions made by the employer. Whereas club cannot be said to be integrally connected. Therefore, my lord, the second point which I invite your lordships to decide is whether, my lord, the club employees can be said to be of the same status of that of canteen employees. Because, my lord, the right to ask for regularization flows from the nature of the establishment in which the employees are working.
Yes.
Well, these are the two fundamental questions, and coupled with that is, well, what is the position of law if KOPT makes some provisions in the club, like meeting the deficit?
Yes.
I'll demonstrate from the records that much emphasis has been laid on the fact that the deputy chairman, by virtue of his post, is the president of the club. Please consider, my lord, whether this kind of an arrangement will bring the club under the direct control of the port or the board. But there is no whisper as to how, my lord, the regular employees of the board or the port are employed, under which law. But this is, my lord, one of the basic things. I'll come back to this. This is
Mr. Dotto, please satisfy us that
yes.
that tends to your arguments have to made it would be a reappreciation of the all the facts.
Right.
Whether that can be done in
The 6 points or questions that have been quoted here. 118 of the stay application. But the first point is, who appoints the workers? Even repetition.
yes, club appoints.
Yes. Now, please have a look to 1 or 2 appointment letters. Yes. my lord, I'll place a few documents, my lord, from the writ petition.
রিট পিটিশন
না আরেকজন জজ সাহেব লাগবে।
এগুলো কি দিয়েছে? এইগুলো কি?
Two copies.
No, we have Mr. Jana. আচ্ছা না থাক ওনার ওনার
Your lordship have only one copy.
এইটা কি আরেকটা কপি আছে? থাকবে কি করে রিট পিটিশন? ও দিয়েছে দাও তো। এটা কোনটা? ও ভলিউম 1 ভলিউম 2 আছে।
3 volumes are there.
3 ভলিউমস।
3 volumes.
আমি ওই যে বললাম, একটাই কবিতা ওটা বড় পড় হ্যাঁ
ওটা নিয়ে নাও। না একটু সাইডে রাখো।
ওইটা একটা রিপিকশন কপি আর একটা ওরা দিচ্ছে দুটোই দিচ্ছে।
হ্যাঁ দুটোই দিয়ে দাও, দুটোই দিয়ে দিচ্ছে। খুব কষ্ট পেয়েছে অর্ডারটা, জেরক্স করে নিয়ে এসছে। Yes, Mr.
My lord, for example, please have a look to my one appointment letter, which your lordship would find, my lords will find, my lord, at page 42 of the writ petition,
Volume 1.
হ্যাঁ
the volume 1 of the writ petition. My lord, here, my lord, the appointment letter would answer, my lord, 3 points. Point number 1, who appoints the workers? Point number 3, who has the authority to dismiss? Point number 4, who can take disciplinary action? And point number 5, whether there is continuity of service. The appointment, from the appointment letter, my lord, we can answer these 4 points.
Yes.
My lord, may I please this? I am directed to offer you. Who is writing this? Well, this is the deputy chairman. I'm sorry, secretary of the club. I am directed to offer you a temporary post in the scale and rate of pay specified about something plus allowances as admissible. Then please take, my lord, 3. The appointment will be temporary in the first instance, and you will be on probation for a period of 1 year or such extended period or periods as may be decided by the executive committee of the CPT officers club. At the end of the period, probationary period, including extended period, if any, your services will be terminated unless your work and conduct are found to be satisfactory by the club. The club will not entertain or enter into any correspondence on the question of your suitability or otherwise for the post or assign any reason in this connection. Then please take 6. Without prejudice to the above, this appointment is terminable on 1 month's notice from either side. Then please take 8. You will be bound by each and all of the rules, regulations, bylaws, orders, notifications, resolutions of the club now existing or to be framed hereafter from time to time, and in particular those relating to the work, conduct and discipline, and any other matter relating to the terms and conditions of your service. Then please take para 9. If at any time it comes to the notice that any information furnished by you in your application or in the declaration form is false, your service will be liable to be terminated without any further reference to you. Then 11. If you are prepared to take appointment on these conditions, please signify your acceptance by returning this form duly signed by you in the presence of 2 responsible persons. A duplicate copy, etc., that is not important. Then, my lord, Sergeant sir. Now, my lord, this from page 42 to 73, my lord, are the appointment letters. My lord, I as a sample, my lord, I place one of
7273.
Yes,
13 employees.
13 employees. So there's another document at page.
Mr. Dutta.
My lord, with this, my lord, please take me to the second volume, page 186.
Tribunal ছেড়ে দিয়েছে। বুঝতে সুন্দর order-টা বের। Yes, Mr.
My lord, appointments are preceded by advertisement. Advertisement, your lordship would find, my lord, at page 186, that is volume 2.
Yes. Yes.
186.
The CPT Officers Club, Holdia, inviting application for the following temporary vacancies for their guest house at Holdia, such and such. These are the posts, etc. Age, so and so. Please turn the page 187. Clause number 1, after 5. The posts are purely temporary in nature and the appointment of the candidates will be governed by the rules and regulations framed by the club committee from time to time. Therefore, my lord, applications were advertisement were published and advertisement made by the club. Appointment letters issued by the club. The employees will be governed by the rules of the club, not that of the statutory rules of recruitment and other things of the Kolkata Port Trust. Now, my lord, if your lordship may kindly take, my lord.
Please come to the next page, Mr.
Yes, my lord. 187.
88.
Yes, my lord. Creation.
Refer to your innovation proposal. Deputy Chairman considered and approved the creation.
Yes. It's not the board. It's not the board of trustees.
Deputy Chairman of KOPT,
Yes, my lord, he is merely an
a
officer.
member of the trust.
Yes. He is a member of the board of trustees of the port.
Very good.
He is also the president of the club.
So your argument is that this deputy chairman is certainly an employee of KOPT.
Right,
So he was the authority competent to approve the creation of post,
right.
and he has approved the post
Yes.
in which you have been inducted.
Yes. I mean, my learned friends.
I mean, there.
Yes.
Now, your argument is that we have to view deputy chairman's extent of authority, treating him to be a member of the board. Now, what is the
Well,
difference?
the argument is that any action of one of the officers of the board, even if he is the chairman, is not the action of the board.
So this creation action of deputy chairman
Yes.
is not a decision of the board, you mean to say?
Yes.
So how do you substantiate that?
Yes. The relevant recruitment rules of the board of the KOPT will demonstrate that. Only one addition.
It's admitted that he has created.
Yes, yes. But in fact, Millard, in the Kolkata Port Trust, there are two deputy chairmen. One is posted, Millard, in the main building or in the main port at Kolkata, and the other at Haldia. Now, this deputy chairman is the deputy chairman of Haldia. But I can give you, Lordship, an example. Millard, take an example of Kolkata Municipal Corporation. Millard, the Kolkata Municipal Corporation has a commissioner. The commissioner has certain powers to decide, to do this, do that, etc. But these are the powers exercised by him, conferred by the main statute and the delegation of power. Now, these exercises are exercises of the chief executive officer or the commissioner of that body. There is a difference between a decision of this executive officer and the decision of the main body, for example, municipal corporation. Which are the decisions of the municipal corporation? The decision of the board of councillors.
You mean to say that this decision has not been ratified by the board?
No.
And you have placed them in regular scales of pay?
Yes, yes, that can be. That can be.
Yes.
Therefore, my lord, the first question is the deputy chairman's actions, whether it can be called to be the action of the board. In my very humble submission, the action of the deputy chairman is only enabling the running of the club. This does not, my lord, take it to the level of the port or the board having direct control over the club or functioning of the club. He is one of those high rank officers who takes decision as president of the club.
So was this argument advanced before the tribunal?
My lord, to be honest, not in that sense. Yes. Not in that sense. But my lord, these go to the root of the matter.
Yes.
Now, my lord, now kindly take, my lord, page 101 of the stay application.
101 of the stay.
101 of the stay application. On the disciplinary control aspect.
Yes.
My lord, this is, my lord,
118. 118.
101. Where 118, my lord, is the 6 questions. Now, my lord, I am on, my lord, the evidence that was before the tribunal.
101.
101.
This is relating to which point? This
Disciplinary control.
discipline.
Where who's issuing it? The honorary secretary of the club. To Shomen Das, so and so. Subject is alleged negligence of duty in performing, alleged negligence in performing duty. In day shift on so and so, you were on duty in so and so place. It has been alleged that you had not recorded the said dinner booking properly, and the same had not has not only resulted in severe harassment to the family members of Sri Roy, but also the incident had brought disrepute to the functioning of the club. In view of the above, you are directed to submit your explanation so and so. Now, my lord, these documents, which I have just placed before my lords, that is page 142 to 73 and 186 of the writ petition, with page 101 of the stay, my lord, takes care of point number 1 at page 118.
And point 4.
Point 4 and point 3 also. Where the appointment letter also says who's going to dismiss.
Yes.
Point 5 also, because the continuity of the service mirror is in the appointment letter. Now kindly take, my lord, point number 2. Who pays the salary stroke remuneration? My lord, kindly take, my lord, pages 145 and 147 of the writ petition. In volume 1. But this is a bank statement. So please see, my lord, the second line from top, after, my lord, the account number, the Calcutta Port Trust Officers Club. My lord, the club credits the salary to the employees' bank accounts. My lord, 2 of the persons with whom, my lord, we are concerned, their names, my lord, has been highlighted. The first one is to Dilip Shokar, extreme on the extreme right hand side.
Yes.
Under narration. Then we are after 7-8 items, Somendranath Das. Then please take, my lord, 147. এটা কি সবাই এতে ইনভলভ? 147 এ যাদের নাম আছে। Then Millard, before that Millard, we have to forward the money to the bank. This is Millard page 147, address to the manager of the bank. We are forwarding check number etc. for the sum total amount of rupees etc. to place the amount to the credit of the following names account detailed in the statement below.
Stop there.
Now these are Millard the workers.
Now, who issues this statement? This is the deputy chairman. Whose signature is here?
Millard, it is I believe
Oh, Holdia doc.
Holdia doc.
No, this is not of the club. This is the amount is drawn from some other account and is being deposited.
No, Millard, this is forwarded by the secretary. Please take the fourth line from the top. Just above the table.
Oh, treasurer.
On the right hand side secretary, on the left hand side treasurer.
Whose signature is this right hand side bottom?
Millard, I have to take instruction to that. এই signature টাকা এটা 100 এই রিটার্ন সরি হ্যাঁ রিটার্ন
Alright. And this check is drawn against.
these employees. But the names are over there.
This check must have been drawn against some account. Which is that account? Is it the account of the club or account of the board of trustees?
Maybe it is, Millard, I believe it is of the club, because otherwise I can draw a check and forward it to someone. Maybe I'll take that instruction also.
Yes, yes.
To dispel doubts, maybe I'll take that instruction. It is জেনে নিস তো 147 এ যে চেকটা দেয়া হয়েছে হ্যাঁ সিল তো কমপ্লেক্স হ্যাঁ সিল তো কমপ্লেক্স নো ডাউট Therefore, my lord, this is a document to answer, my lord, point number 2.
Yes.
Now, my lord, on the appointment aspect, my lord, the rules are part of the pleadings or the proceedings, I mean records. My lord, please take my lord page 131 of the writ petition. 131. May I please take me to page 132. First is, my lord, it is published in the Gazette. At page 132, your lordships would find that the rules are published in the Gazette. I mean the board's rules by the central government, Ministry of Transport. Now kindly see the notification. What does it say, my lord, at page 132? In exercise of powers conferred by subsection 1 of section 124, read with subsection 1 of section 132 of the Major Port Trust Act, the central government hereby approves the following regulations of the Kolkata Port Trust as per the schedule attached. First, my lord, the central government's approval is required. Then, my lord, it is required to be published in the official gazette. Now, where are the rules? Please, it starts from page 133. Please take 134. In exercise of powers conferred by so and so of the Major Port Trust Act and in supersession of such and such, so and so, the Board of Trustees, this is very important, of the Port of Calcutta hereby makes the following regulations. So there are three aspects. First is board has to frame the regulation. Second is it has to be approved by the central government. And then it has to be published. This is as per the Major Port Trust Act. I'll show the provisions.
Yes.
Now, please take regulation 1 II, where the enforcement is on publication in the official gazette.
Where you are reading?
Regular page 134, regulation 1 II
Oh, they will, yes, publication
in the official gazette. Now, please take 3A.
Yes.
Who are the appointing authorities under the Port Trust? Appointing authority means appointing authority as specified in Schedule B. Schedule B is at page 144. First is the central government for the heads of departments. Chairman Millard for scales exceeding rupees 2,400. Exceeding 2,800 and not exceeding 3,700. Third is deputy chairman shall be the appointing authority in respect of posts. The maximum of pay scales which exceed rupees such and such. Then fourth is deputy general manager for such and such. Or Millard, the club, president of the club, secretary of the club, whoever he is appointing on behalf of the club. Those appointments, Millard, are not under this statutory regulation.
Yes.
Then kindly takes, Millard, regulation number 4 at page 135. The authorized permanent and temporary strength of various grades shall be as in the schedule of employees prepared and sanctioned from time to time under section 23 of the Major Port Trust Act. Gradation of employees, a gradation list of employees, both temporary and permanent, shall be maintained section-wise or unit-wise for each grade. Then comes the constitution of the selection committee. Promotion committee, confirmation committee, etc. So and so committees shall be constituted for each category of post other than the post in clauses such and such of section 24 as indicated below. For the post carrying scale of pay of etc., the committee will be constituted of deputy chairman Holdia, deputy general manager, head of the department, head of the concerned division. The club cannot fit in either of these committees. Then deputy chairman Millard has a right to co-opt. Then please take B. For class 2 post, the committee shall consist of so and so, so and so. Then we are for the lower post, please turn the page. Clause C, top. In respect of class 3 and 4 posts, the committee shall consist of head of the respective division of the representative, not below the rank of junior assistant manager, that is the chairman, and II is head of the personal and industrial relation division of his or his representative, not below the rank of so and so. Then we'll note not required for our purpose. Then please take Millard 6. Method of appointment. All appointments to the post to which these regulations apply shall be made in accordance with the provisions of these regulations. Appointment may be made either by promotion or transfer of employees or by direct recruitment. Then promotion, selection, Millard, kindly skip over those, Millard. Please take Millard clause number 7, regulation 7 at page 137.
No, Mr. Dotto, page 136, 6.1,
6.1.
which
Yes,
is
Millard.
just now placed.
Yes,
All appointments to the posts to which these regulations
Right.
apply.
right.
Now, that what are those posts? That are Schedule A and Schedule B.
Schedule A.
Schedule A. Kindly come to page 144.
Yes.
Class 4 posts are excluded from these regulations.
Yes, Millard, it's there. Roman,
Schedule A.
Schedule A,
Roman-
the last one.
Yes, Roman 4. All posts not covered by 1 to above carrying a pay scale, the maximum of which is 927.
Yes.
So, in respect of those posts,
Yes.
these regulations are not governing.
No, in this Millard,
Class 3 posts,
Millard, class 4 post Millard has been defined as all posts not covered by 1, 2, and 3, carrying a scale of pay, the maximum of which is so and so. So class 4 is also Millard included in it. Now, how they are distinguishing class 4 from 1, 2, and 3? See that all other posts except those mentioned in 1, 2, and 3 having a maximum scale of 927
Hmm.
or below per month. Now, Millard, kindly take me, Lord, the next page. Probation. Regulation 7. Regulation 7 prescribes a probationary period. These are all for those employees, Millard, mentioned in Schedule A.
So
Who-
your contention is regulations do not cover these appointments. This is your contention.
Right.
Yes.
Therefore, these
As such, they do not earn any right under the said regulations for being a. Yes.
and Millard, they are not my employees by no stretch of
Fine.
imagination.
Yes.
We need to accept the
Hmm.
condition.
Mhm.
Yes.
Now, please take Millard 12. Millard only indicating where your lordship has Millard understood the point.
No, your argument is that.
Yes,
And
yes.
to support that, you are referring
Yes,
to
yes.
the clause.
Then please take Millard manner of direct recruitment at 12, page 140.
Yes.
all appointments by the appointing committee, appointing authority, on the recommendation of the selection committee. Appointing authority at Schedule B, selection committee, regulation 6.
Hmm.
Therefore, my lord, there is a marked difference between an employee of the Kolkata Port Trust and an employee of the club, going by the appointment letters, my lord, and my lord, these rules. So, my lord, these takes care, my lord, of point numbers 1 to 5 at page 118 of the stay application. Now, my lord, the control aspect. Clause number 6. Extent of control and supervision, and whether there exists complete control and supervision. This is very important, complete control. Now, first, kindly, my lord, have a look to, my lord, the writ petition, page 244. Volume 2, my lord. পড়তে পারছি নাকি? পড়তে পারবি? It is a handwritten document.
Right, copy.
In my chamber, I read it with a magnifying glass. I don't have it here now.
You could have brought your glass along with you.
Yes, I should have.
No type copy.
But I'll get it
The
typed.
Officers Club has
Yes.
limited source of
Revenue
earning.
The only source being sale of food and
Members' contribution and
members'
grant.
contribution and general fund.
Grant.
I'm so sorry, Mira, I can't read.
Particularly cost and items as in given to the members. These
Okay.
funds are not at all sufficient to provide such and such. Hence, it is submitted that all expenditure relating to and or arising out of should be borne by CPT
or the Officers Club. No,
If the Officers Club is
unable to meet the expenditure. In view of the above, the deputy chairman may kindly approve in principle to 1, CPD bearing all expenditure relating to and or arising out of guest house
restitution of
staff uniform,
guest house activities, staff uniform,
guest house upkeep,
etc., crockery, etc.
crockery, something. Then payment of above bills, if otherwise found to be in something by finance. এটাকে টাইপ করাতে হবে।
মানে ফিনান্সের অ্যাপ্রুভাল লাগবে, তাই তো?
Read page 243 also. But the starting is at page 243. The various bills submitted by the club regarding uniform of the employees, upkeep, expenditure and others which have been kept in something for a decision to who as to
incurred the cost.
incur the cost is being considered or something. As per the decision
Between the club members.
the some committee
Club কি একটা committee.
Has to be placed before the deputy chairman for his kind approval.
yes এ পড়া যাচ্ছে না। Then joint manager
Recommendation.
approves this and says the deputy chairman may kindly
Deputy chairman.
see the following
on the recommendation of
bills are pending something from time to time.
Yes,
But the next document, my lord, your lordship should find, my lord, at page 261 regarding uniform. This is at page 261.
yes,
But this is the club writing to the deputy chairman. 261. Sir, the CPT Officers Club Holdia in its committee meeting held on so and so resolved and recorded at serial number 6 of the some minutes. Staff uniform, regarding uniform, the norm recommended by the GM and approved by the deputy chairman was discussed. The House requested a minor modification by allowing 2 pairs of shoes for the block period of 3 years instead of something as recommended. The president agreed. The president agreed to and advised to write from club. Xerox enclosed. Sir, in view of the above, I submit to your good sir to accord your consent to the concerned authorities in this respect.
Page 262 দেখো। Uniform proposal of issuing one to association block period has been approved by deputy chair. Yes,
Then, my lord, your lordship, kindly have a look to page 276. But these pages, made I'm showing because it weighed with the honorable single judge that even the crockeries, utensils,
yes,
uniform, these are being looked into by the deputy chairman. Page 276.
yes,
Some utensils have been received from the division for the guest house. The said utensils as given below are to be handed over to the club for proper record and use at kitchen. Well, then the utensils are there. You are requested to instruct the office staff to receive the items and make necessary entry in the stock book. Then below there is a handwriting, Mr. Das, to acknowledge receipt and enter.
so all are being done with the approval of the deputy chair.
Yes.
Uniform, shoes, crockery,
Yes.
wages, everything is being done on the approval of the deputy chair.
Deputy. As the president of the club, not on behalf of the board. Board has not authorized him, when at least no document is available in this proceeding.
Your argument is this action is as president of the club, not as a member of the board.
And even to discharge these functions as a member of the board, the board has to authorize him. Now the most important aspect, salary and finance.
This club, Mr. Dotto, must be having a governing body.
Yes,
Or a
it is run through a committee.
Is done through a committee. So why the approval of committee has not been taken?
Yes.
Committee has not been given. Your argument is that this action is by the deputy chairman as the president of the club. Then where is the decision of the committee? That we are empowering the president to approve this fund. How can you detach yourself from the, please, in course of argument, please.
Yes, yes.
Yes.
Milord, one Milord, as has fallen from my lord, Milord, who runs the club? The club is run by a committee.
Yes, that you have said.
That committee, Milord, has
the subscription received and everything, the fund is generated.
yes.
And as he is the deputy chairman, is the president, his approval is being taken
Right.
for the purpose of expenditure.
Right.
Yes.
Now, Milord, these approvals, Milord, what
Is not as a member of the board
as a member of the board or on behalf of the board.
or on behalf of. Yes. Board has not authorized the deputy chairman to do this. Yes.
Then Milord 242 and 245.
Yes.
Oh, achha.
Yes.
But one query from the court, Milord, in regard to page 147, the stamp at the bottom. 147.
Oh, that is volume 1.
Volume 1, last page.
Yes.
This stamp is the stamp of the bank, Punjab National Bank.
Complex.
Punjab National Bank, Huldia Dock Complex.
Thank you. Thank you. Yes, Mr. Rao. We can come to the judgment now, which you are.
Yes, very good. Now, my lord, first is but only a few provisions were from the Major Port Trust Act. Very, very few
That
provisions.
is annexed here, Mr.
No, no, it's not.
Oh, NS.
What is it? India?
পড়াশোনা করে এসছে। We can retain these copies, Mr.
Yes. Lordship can.
He has in abundance.
20 long years, Mr.
Because new act has came.
Yes, now there's a new act.
Thank God that will not be placed.
But please take me at section 3 first. This is how the board is constituted. With effect from such date as may be specified in the official gazette, the central government shall cause to be constituted in respect of any major port, a board of trustees to be called the board of trustees of that port, which shall consist of the following trustees, namely, number 1 is the chairman to be appointed by the central government, then 1 deputy chairman or more as the central government may deem fit to appoint, then not more than 19% in the case of each of the port of Bombay, Calcutta, Madras, and not more than 17 for the others.
Yes.
Then please take, my lord, the section 5, which says that the board will be a body corporate. Then section 23. A board shall from time to time prepare and sanction a schedule of the employees of the board whom it deems necessary and proper to maintain for the purposes of this act, and such schedule shall indicate therein the designation and grades of employees and salaries and fees and allowances which are proposed to be paid to them. But the club employees will not come under this. Subject to correction by my learned friend. Then, my lord, section 28, my lord, under which, my lord, those regulations are framed.
27.
Achha, 27 পড়বো। Yes. Well, my friend wants me to read 27, section 27. Notwithstanding anything contained in section 23, the power to create any post, whether temporary or permanent, shall in the case of a post, the holder of which is to be regarded as the head of a department, or in the case of a post, maximum of the pay scale of which, exclusive of allowances, exceeds such amount as the central government may by notification in the official gazette fixed by be exercisable by that government. In the case of post other than those referred to in clause A, the maximum of pay scale of which exceeds such amount as the central government may from time to time by order fix in this behalf, or where no such amount has been fixed is not less than rupees 1,000 rupees be exercisable by the board with the previous sanction of the central government. In the case of any other post, be exercisable by the chairman. Therefore, my lord, if section 27 is to be exercised, then, my lord, creation of the post must be, my lord, in the manner specified in section 27. A, B, sanction of the central government. C, exercisable by the chairman.
Yes.
Then please take note section 28, which is the power to make regulation, my lord. Now on the salary aspect, please take note section 88. Eighty-eight. First is under 87, where a general account of the port is to be maintained. 87 says all money received by or on behalf of a board under the provisions of this act, and all money received by it as the conservator of the port and of the port approaches, or as a body appointed under subsection 1 of section 36 of the India Port Act, shall be credited to a fund called the general account of the port. So where the revenue that is collected by the port is to go to the general account. Now please take 88(1)(b). The money credited to the general account under section 87 shall, subject to the provisions of section 89 of this act and of section 36 of the Indian Port Act, be applied by the board in payment of the following charges, namely, please take B, the salary, fee, allowances, pension, gratuity, compassionate allowances, and other money due to the chairman, deputy chairman, and other trustees, the employees of the board, and surviving relatives.
Yes.
So the money or the salary of the employees of the Kolkata Port Trust has to come from this general account. Here, your lordships have found, Miller, the salary is being paid from the bank account of the club.
So your contention is the money which is given by the deputy chairman to the club is not from this account. Yes,
And one last provision, that is section 124.
124,
Of
120,
Major Port Trust Act.
123.
124.
One twenty.
But 123, Millard, is the board's power to make regulation on so and so factors. And 124 says that the regulations must be approved by the central government. And it must be published in the official gazette.
Yes, that you have shown us
Yes.
from the regulation.
Therefore, Millard, this is the scheme of the act.
Yes.
Hmm.
Anything else, Mr. Dotto?
No, this is Millard on these aspects. Now, Millard, on the judgments.
Yes.
Millard, I have drawn your lordship's attention that the Honorable Single Judge, Millard, had referred to the NALCO's judgment. But Millard, there is no discussion on that aspect.
এই judgment গুলো এখানে আছে দাও তো ওই কপি আছে বলে দাও তো জাজমেন্টের এইটা কি
Copy আছে তো NALCO?
Yes, which one you are placing, Mr. Dotto?
Millard, 2014, but this is referred to by the Honorable Single Judge, Millard, at
14.
14.6 SCC 756. তিন কপি আছে
756.
আমি দিইনি তো আমার
জানি না
না
756 রেফার করেছে প্যারাগ্রাফ 30. You have the copies?
Yes, yes. Millard, please give me Millard 2 minutes, Millard. I'll take out my copy, Millard.
No, Mr. Dotto, you take one copy, we will share one copy. No problem.
Well, so that if required, your lordships can mark it, Millard. আছে জানি না।
Read petition আছে annexed.
Yes, no,
It
it has
is
been
an-
referred. It is referred in the file, in the file, all judgments are there.
No, it is not there.
no, it is not.
The file.
Anyway, my lord, I have
No,
given-
in the read petition, it has been annexed.
No, it was relied upon.
It was,
Anyway, my lord, I have added two copies.
14.6
একটু খুঁজে এই অজয় দেখো না জাজমেন্ট গুলো ও আচ্ছা আচ্ছা এখানে 14.6 আছে তো এইটা গোলাবে না এটা মার্কিং আছে কে চোদ দিয়েছে
slow vision.
is not for the purpose of only control to ensure that the schools run smoothly and properly. Better control.
Yes.
Please, sir.
With first is, please have a look to paragraph 25 first.
There are 25.
Yes. The court noticed that the implementation committee, canteen committee, which was running the canteen, consisted of certain members, 3 out of which were nominated by the bank. This was held to be a non-determinative factor. Following decision on this aspect is also material, and therefore we extract the same hereunder. Moreover, there is no right in the bank to supervise and control the work done by the persons employed in the committee, nor has the bank any right to direct the manner in which the work shall be done by various persons. The bank has absolutely no right to take any disciplinary control or direct any canteen employee to do a particular work. Even according to the tribunal, the bank exercises only a remote control. In the present case, as pointed out, the day-to-day supervision and control vests with the managing committee from the appointment till cessation termination. The exercise which is undertaken by the High Court is in the nature of piercing the veil and commenting that real control vests with NALCO. Though we would come to this aspect little later, it is necessary to point out at this stage that whether the arrangement contract is sham or camouflage is a disputed question of fact. In the present case, writ petitions were filed, and it is not a case where the industrial disputes were raised by these employees. Then kindly take Willard paragraph 28. And then Nilgiri is considered. More significant case having close proximity with the present one is the judgment in so and so. In that case, Hindustan Copper Limited, the Government of India enterprise, had established a school. Employees of that school claimed that their real employer was HCL. Admitted facts were that the school was established by the HCL with the object of benefiting the children of the workers of HCL. Even financial assistance was provided to the school. The court, however, came to the conclusion that only by giving financial assistance, HCL did not become the employer of the teachers and the staff working under the school. They were held to be the employees of the managing committee of that school. Therefore, my lord, in this case, HCL had established the school for the benefits of the children of its employees and provided finance. Then also, my lord, it has been held that it is not the school of HCL and the employees were not the employees of HCL, but were the employees of the managing committee of the school. That apart of the discussion which has direct bearing on the present case runs as follows. We have heard the learned counsel for the parties and perused the record. The basic question before us is whether A mandamus could be issued against the management, the learned single judge relying on the division bench in an identical matter pertaining to Bharat Coking Coal Limited dismissed the writ petition. This issue was examined in an analogous writ petition, and in the aforesaid case, this issue was extensively considered as to whether the management of the school is the direct responsibility of HCL or not. After considering the matter in details, the learned single judge relying on the aforesaid judgment found that there is no relationship of master and servant with that of the teachers and the other staff of the school with HCL, as the management of the school was done by the managing committee, though liberal financing grant was being made by the corporation. By that, there was no direct connection of the management of HCL with that of the management of the school. Though through various communications, an impression was sought to be given that the school is being run by HCL, but in substance, HCL only used to provide financial assistance to the school, but the management of the school was entirely different from the management of HCL. Giving financial assistance does not necessarily mean that all the teachers and staff who are working in the school have become the employees of the HCL. Therefore, we are of the view that the view taken by the learned single judge appears to be correct, that there was no relationship of the management of HCL with that of the management of the school, though most of the employees of HCL were in the managing committee of the school. But by that, no inference can be drawn that the school has been established by HCL. The children of the workers of HCL were being benefited by the education imparted by the school. Therefore, the management of HCL was giving financial aid, but by that it cannot be construed that the school was run by the HCL. Therefore, under these circumstances, we are of the opinion that the view taken by the learned single judge appears to be correct. Then kindly takes me to paragraph 30 and 33. No doubt there may be some element of control of NALCO because of the reason that its officials are nominated to the managing committees of the school. Such provisions are made to ensure that the schools are run smoothly and properly by the society. It also becomes necessary to ensure that the money is appropriately spent. However, this kind of remote control does not make NALCO the employer of these workers. This only shows that since NALCO is shouldering and meeting the financial deficits, it wants to ensure that the money is spent for the rightful purpose. Now, this is the Millard crux. It is Millard only to ensure that the money is spent for rightful purpose. Then kindly take Millard paragraph 33, the last one. Insofar as their service conditions are concerned, as already considered by even the respondents themselves, their salaries and other perks which they are getting are better than their counterparts in the government schools or aided, unaided, recognized. 33 minutes.
33.
Yes, madam. Insofar as their service conditions are concerned, as already considered by even respondents themselves, their salaries and other perks which they are getting are better than their counterparts in government schools or aided, unaided, recognized school in the state of Odisha. In such a situation like this, even if for the sake of argument it is presumed that NALCO is the employer of these employees, they would not be entitled to the pay scales which are given to the other employees of NALCO, as there cannot be any comparison between the two. The principle of equal pay for equal work is not attracted. Those employees directly employed by NALCO are discharging altogether different kinds of duties. Main activity of NALCO is the manufacture and production of aluminium and aluminium for which it has its manufacturing units. The process and method of recruitment of those employees, their eligibility conditions for appointment, nature of job done by those employees is entirely different from the employees of the school. This aspect squarely dealt with in SC Chandra, where the plea of parity in employment was rejected, thereby refusing to give parity in salary claimed by the school teachers with class working under the government of Jharkhand and BCCI. The discussion which ensued while rejecting such a claim is recapitulated hereunder in the majority opinion authored by A.K. Mathur J. After going through the order of the division bench, we are of the opinion that the view taken by the division bench of the High Court is correct. Firstly, the school is not being managed by BCCL, as from the facts, it is more than clear that BCCL was only extending financial assistance from time to time. By that, it cannot be saddled with the liability to pay these teachers of the school as being paid to the clerks working in BCCL or in the government of Jharkhand. It is essentially a school managed by a body independent of the management of BCCL. Therefore, BCCL cannot be saddled with the responsibility of granting the teachers the salaries equated to that of the clerks of BCCL. The learned counsel for the appellant have relied upon Article 39D does not mean that all teachers working in the school should be equated with BCCL or the Government of India for application of equal pay for equal work. There should be total identity between two groups. That is the teachers of the school on the one hand and the clerks in BCCL. And as such, the teachers cannot be educated with clerks. I mean, it should be equated with the clerks of the state government or of BCCL. The question of application of Article 39D has recently been dealt with in such and such.
Yes.
Therefore, my lord, here, my lord, the Supreme Court says that some provision of financial assistance and some control of the financial assistance will not make that organization to be an organization directly controlled by the KOPT. But going by the expression used by the Supreme Court, that it is only to see that the money disbursed by them is used for the rightful purpose. Para 30, last sentence.
Yes, Mr.
Then, my lord, 2007, volume 8, Supreme Court cases 279.
Yes.
Please give me a moment. আছে কপি? না না এক্সট্রা আছে 78271 বুঝেছিস?
SC Chandra,
Yes.
relying upon which the NALCO
Yes.
was done.
May kindly note, Millard, only paragraph 8 of this judgment.
Paragraph 8.
8.
Yes. Any other judgment, Mr. Krishna?
Okay. Millard, the next is 1996, volume 3, SCC 267. এটা আছে তো?
267.
96-3, SCC 267.
Yes. Page.
Page 267.
Yes.
Para
13 and 20.
13 and 25. বলছে না কেন কি?
Yes.
না এটা খুলেছে, বড্ড দেরি হচ্ছে করতে।
Yes. Yes, sir.
কি করবে? Continue করবে? Yes.
But this is the on the obligation part, para 13. One aspect is clear. The Reserve Bank of India is under no statutory or other legal obligation to provide canteen facilities to its employees. The tribunal has not found any such statutory or legal obligation in the bank. That apart, we have to bear in mind the following salient features in the matter of recruitment of the staff by the banks. It is a well-known fact that recruitment of staff inclusive of class 4 to the bank is done by a selection board, and there are guidelines governing the process of selection. So also in the case of Reserve Bank of India, the process of selection and recruitment of the staff is by a different board, and appropriate qualifications are prescribed for the particular post. In the case of persons employed in the canteens, they are not subject to the rigor and discipline of the above rules and methods of selection. This distinguishing feature is relevant in adjudicating the controversy raised herein. The tribunal has held that regarding canteens run by the implementation committee, the bank exercises remote control, which is as effective as any. Regarding canteens run by cooperative societies, the tribunal has held that they are non-statutory but recognized canteen, and by nominating representative of the bank to the committee, it exercises control. Regarding the canteens run by the contractor, non-statutory, non-recognized canteen, in the absence of distinguishing features are highlighted in para 38 of judgment, they could be said to be recognized canteen by the bank, and the persons employed by the contractors are also entitled to the benefit similar to the one offered to the persons employed in the canteen run by the implementation committee and cooperative society. The question that falls for our consideration is whether the aforesaid view of the tribunal is justified in law, holding that the instant case is covered by the decision of this court in MMR case. Now kindly take me to para 25. Now we have to examine the reasons which persuaded the tribunal in this case to hold that the instant case falls within the ratio of the ratio laid down by this court in MMR case. In all the three different categories of canteens, canteens run by the implementation committee, cooperative society, and contractors, the bank was making grant by way of subsidy at 95% of the cost incurred for payment of salary, PF, contribution, gratuity, uniform, etc. Besides providing fuel, water, fixture, utensils, furnitures, electricity, premises, etc., free of charge. We will take up the individual facts highlighted by the tribunal in respect of different categories of canteens. When the question between the employees in relation to the Reserve Bank of India and their class 3 workmen came up before Justice Dhingre, on a reference, on an earlier occasion, the bank had submitted that the adequate canteen facilities are available to the employees of the bank, and that the bank has provided facilities in that regard. Regarding the canteen run by the implementation committee, out of the 12 representatives, 3 of them are from the bank: the currency officer, personnel officer, and the officer from the personnel policy department. The currency officer is always the chairman of the canteen committee. The bank relieved 4 employees who are in the committee, 2 for full day and 2 for half day, to supervise day-to-day affairs of the canteen. The committee cannot increase the strength of the canteen employees without permission of the bank. The rates of eatables also cannot be revised without consent of the manager. They cannot effect any wage revision without approval of the bank. The bank is also reimbursing the expenses incurred over the periodical medical checkup of the employees attached to the kitchen and counters. In these circumstances, the tribunal held that the case clearly falls within the ratio of MMR case. Since the bank exercises remote control, which is as effective as any. As against the above aspect, the fact remains that according to the bank, it has only a limited role to play regarding the functioning of the committee and does not have any control whatsoever on the employees engaged by the committee so far as taking of disciplinary action against any particular employees concerned. The bank has further brought out in cross-examination of the employees' representative that the recruitment of workers for the canteen is made by the canteen committee, and the attendance record as well as the sanctioning of leave to the workers is done by the committee. It was brought out in evidence that the only role played by the bank in the running of the canteen was the nomination of 3 members, it is common ground that canteen run by implementation committee is not under any legal obligation, as was the case of MMR case, Khan case. Moreover, there is no right in the bank to supervise and control the work by the persons employed in the committee, nor has the bank any right to direct the manner in which the work shall be done by various persons. The bank has absolutely no right to take disciplinary action or to direct any canteen employees to do a particular work. Even according to the tribunal, the bank exercises only a remote control. We are of the view that in the absence of any obligation, statutory or otherwise, regarding the running of canteen by the bank and the details relating to thereto similar to Factories Act or Railway Establishment Manual, and in the absence of any effective or direct control to the bank in the bank to supervise and control the work done by various persons, the workers in the canteen run by the implementation committee cannot come within the ratio laid down in SWAS.
Yes.
But here, my lord, your lordship has seen that the entire finance is given by the bank. Uniform, utensils, whatever, my lord, are the case over here.
Yes. Can you finish it today, Mr. Dotto? 2
Another
PM, can you
10 minutes.
Huh?
10 minutes.
Then we come back at 2 PM.
At 2 PM, I've got some difficulty. Kindly. But permit me 5 minutes for that finish. Then the Saluja judgment, Miller, kindly have a look to that. Anisha? Oh. না সালুজা হচ্ছে 13-15 পেজ 85 নেই না? But in that case, kindly give me 5 to 10 minutes on some other domain. But the sorry.
Tomorrow?
Very well,
Tell us when you people.
my problem is not I can't tell the court. The difficulty is that these election matters for that
If you can finish your argument, we can hear
yes,
them.
yes.
Just one
For
thing,
reply, if you want any time, we will give you on the.
there are two adversaries against me, two adversaries, the two parties, my senior administrative client and supporting the club also. So
Club is adopting.
yes,
Mr. Dotto
if
subject.
if he has some, so
If it is on record, very good.
so if he adds something, let us him also finish, then we can reply. So it will save your lordship's time, so that we are otherwise ready.
But could it be?
Then it
could
will
it be?
go over to the next week, Mr. Yashoto Janto ki.
I've got a prayer, Miller. In the criminal case, the government of India, is insisting that we must produce some stay order. Because the criminal case has been started. On the last occasion, my learned friend was very kind enough to say that nothing would be done. But please have a look to this letter of 7th of June.
Will be initiated. That is there.
No.
অর্ডারটা জানি জোসেফ ওখানে বলেছি
এটা আরেকটা চিঠি।
ম্যাটার ফিক্স ফর হিয়ারিং
So it is your
Furnish a copy of the stay order granted by the division bench of the Honorable High Court Calcutta in the matter, and also intimate the present status of the appeal, as in the absence of any stay order, matter has to be proceeded in accordance with law.
criminal proceedings where?
এছাড়া কি প্রসিডিং হবে?
Okay.
আর কি প্রসিডিং হবে? এছাড়া আর কোনো প্রসিডিং স্কোপই নেই।
Execution application for 33 application is filed.
পেনাল অ্যাকশন
হুম।
29 পেনাল
আগেরটা পেনাল অ্যাকশন বলেছিল।
হ্যাঁ 29
হুম।
that is last annexure to the state that was the last annexure to the state.
Well, we are ready even tomorrow. You're subject to your conveyance or lordship, but kindly do not pass in because there is no, in this particular order, there is no threat of paying the penal action.
The appeal from us, we need not appeal, hear the appeal.
No,
We need not hear the appeal then. We will hear the appeal and they will take a.
No. It is not that. I am saying only submitting that no penal threat of penal action in this letter. That's why I am saying.
No, we have written.
But the last annexure to my stay application. 129.
They say that stay order. Huh? What is that? The action we do not.
এই তো দেখো না stay application last page.
তো ওদের গোড়া নিতে হবে।
But your lordships are in the midst of hearing, well, let them not take any
না,
action.
stock exchange order we will take
Yes,
up
that your lordship. না, ঠিক আছে,
and
এটা।
we intimate it to the labor commission.
That your lordship definitely pass.
But Mr. Dottulan, senior advocate appeared
Also, you
before
got that
the
issue with the
applicant. Please the matter for further consideration on.
কবে বলছে? আরে ওটা থাক না, স্টে থাক না, কি অসুবিধা? অ্যাপিল শুনছেন জজ সাহেবরা, অন্য কিছু হতে পারে।
5 তারিখ।
Please the matter for further consideration on. 10th July as fixed at 2 p.m.
10 July.
10 July 2 p.m.
As this
And stay.
in view as this court is in session of the matter, comma, the
Award, we give the reference of award.
129, page 129,
But the last page of my stay application.
and then subsequent.
Assistant Labor Commissioner.
last page,
Yes, page 129.
Thereafter, we wrote a letter to him. He replied to this.
Tension করি। But the award is at page 28 of the stay.
We have not placed the award before us.
So the employees are fighting for the 20 years, and the before the single judge adjournment were taken for successive days.
They have also taken several time adjourned.
No, not at all.
only the petition.
Not at all. Not for a single day.
These are not the issue before this.
Not at all.
These are not the issue before.
Not for a single day.
We ground
Don't make such allegation against the
take out an
advocate. Don't
adjournment.
make
नहीं
such
है।
allegation. You
No,
can make
it
an
is on
allegation.
record.
Saying that the advocate has
Chandra.
prayed for an adjournment. Why?
This is. Mr. On behalf of Mr. Jaydeep got so many adjournments played. It is on record.
না করো ভাই।
as the present appeal is being heard.
That.
They are not parties before us.
No, they are employees, so they should make make him some
No, we
orders are
had-
being sought for.
Milord, on the last occasion, my lord,
If your lordship
After
states
the-
that, yeah, empty in the impute award,
Assistant Labor Commissioner is a party.
no.
that I don't know, but your lordship has the power to direct them so that your lordship is in season of the matter. I am considering that that is for the interested justice, that should be done.
No question.
As the court is in
না,
session
party
of the
close.
matter,
দরকার নেই।
হয়ে গেছে, conciliation হয়ে গেছে।
respondents are restrained from taking any coercive steps
Yes, yes.
against
In terms
the
of the-
appellants till 15th of July
My lord,
2020
that will
or
suffice.
until further orders, whichever is ultimate.
That will suffice.
No, my lord, as your lordships have rightly observed, The Assistant Labor Commissioner is not a respondent here.
That is what you satisfied.
Therefore, your lordships, Miller, may I
Grant them leave.
Prayer portion of the stay.
Yes,
ask
as
for
for
stay.
stay.
Of the order.
Right,
passed
right,
in the
right.
petition.
So grant them leave, you add them, no problem.
Okay.
That order is sufficient. Otherwise,
Communicate this order, Mr.
yes, yes, no, unless your lordship decides the matter, no authority has the audacity to do anything.
Who is appearing for Union of India? Anybody?
Nobody in the trial court also.
Nobody.
Obliged, my lord. হ্যাঁ।
Yes, it should be Ministry of Labor ছেড়ে দিয়েছে।
You have not invested.
এটা আমার
It's none, Mr. Dotto.
I'm sorry, Miller.
You have just annexed the letter and you have not asked for a stay on that.
No, I'm considering to that.
Miller,
I'm considering to that.
I have
Lordship
pleaded
passed
for stay of the main judgment.
Your lordship passed the appropriate order. I'm considering that. No, I will not take any objection to that. Since your lordship is seizing of the matter, they should not take any steps.
Miller,
Unless
may
your
I-
lordship,
Not take steps, sir.
let them add him.
Parties.
Let them add a party. Kindly, your lordship, grant the leave them to add the
Should
party.
we allow, ask them?
Kindly
let the
kindly do
order
not
of the
stay.
learned
No,
single
no.
judge be stayed
No,
for
they
a
are
limited
not.
period.
I have some issues. Kindly do not. Your lordship is seizing of the matter. Your lordship will decide the matter very shortly. We are ready. Kindly do not stay the impugn order. Last occasion also, your lordship fixed this matter, considering this prayer was made.
Order passed in its petition under the award.
No, award they are seeking. Since your lordship is, they are seeking the award.
Mr. Dotto, finish it off day after tomorrow or tomorrow. We shall hear and finish.
Yes.
We will-
Well, in that case, Friday, Miller, day after tomorrow, is
How long will you take, Mr. Dotto?
not more than 15 minutes. Two or three more judgments.
Exactly. See, you have not prayed for stay of the award also. Justice Ghosh has only affirmed the award, nothing. And they are also not parties. We should not pass unimplementable orders, Mr. Ghosh. This is the problem.
Subject of a change.
Without the
Friday শেষ করতে হবে। সিঙ্গেল জাজের কাছে তার স্টিচ করা।
Well, the Assistant Labor Commissioner is asking me to produce a stay of the order. So kindly, Milord, stays it, Milord, for a limited period. Maybe for 2 weeks.
You have been vigilant, Mr. Dotto. Stay application, there is no prayer. Party is not impleted. We are hearing the matter.
বলছি দাঁড়ান, ওয়েট করো।
Last night, the respondents question. If there are no coercive steps shall be taken against the appellants till 15th of July 2028 or until further orders, whichever is
My lord, my lord,
communicate the order.
my lord. বলছি
10th.
10th,
10th.
10th at 2 p.m.
The original side mentioning,
Come tomorrow.
my lord,
When Thursday, come on Thursday.
Thursday holiday.
Yes, what is the problem?
No problem. Then I'll mention it next week. Man.
Any urgency?
My lord, your lordship had passed an order on 28th of February, not 20. I have a copy of the order with me. What has happened? They have not filed their affidavit as yet.
Remind us on Monday.
Monday.
Remind us on Monday. We will. This then it will be for.
Or next Tuesday when your lordship takes up original side matters.
It's an original side matter.
Yes.
To mention, we would be sitting on. I think on 4th we would be sitting. Before this bench or
Yes,
before any other honorable. Please remind us on 6th July. We shall.
Your lordship kindly says the order passed by your lordship.
You are saying what more I will see. You have said that period has expired.
Yes, sir.
So you remind us on that day. We will.
Okay. 6th July. Well, I'm sorry to have bothered your lordship like that.
ডেলিভারি
ওটার সাথে জাজমেন্টের একটা ইয়েস The judgments, please share the judgments. Whichever judgment you have relied upon. Okay.
appellant in opposite.
For the reason discussed above, no interference is called for in the present appeal. The same along with the connected application are dismissed. Extremely obliged.
Yes, next.
Well, may I only
In this harbor.
no only may I say this with all humbleness. Well, from stay of operation of this sort.
Stay of what? Dismissal.
Very well.
Dismissal of appeal. Yes.
Extremely obliged.
Your names have been incorporated.
Yes, my lord, there was just a spelling error in mine, that is why I was.
Spelling error?
Yes, in my name. It happens,
Judgment.
possibly, my lord, extremely long name happens in most courts.
So it happens also in my name also.
Huh?
Lord,
No, judgment.
The spelling of my name also.
Lord,
Just
n number of permutation and combination.
Devajyoti.
You use A.
I use A. And in most of the judgment, my lord, whichever I like to, my lord, take as a citation or reported judgment.
My lord, extreme number of permutation combinations of Bandyopadhyay.
No. You are D-E-B-O.
B-A. Actually, I pronounce Devo, but it says Deba. D-E-B-A-J-Y-O-T-I.
B-A. And what is your
My lord, Pourush Bandyopadhyay.
spelling of Pourush?
Pourush Bandyo. P-A-D-Y-O.
T-Y-O.
P-A-D-H-Y-A-Y.
এটা একটু ওই PA কে বলো তো এটা।
N number of permutation combinations of Bandyopadhyay I have seen.
ওটা করে ফ্রেশ করে রাখতে পারবেন গিয়ে চেক করে
Sorry for troubling a lot.
Extremely obliged. Sorry for troubling me.
কি order ওই যে ইয়ে appear করেছে মেয়েটা। ওই যে হালদার section 5 আছে।
You don't have connected application.
Miss Roma Haldar is in your room. Roma Haldar, number 15. কি বলতো? You know her?
একটা ফোন করে ফোন আছে
এটাতে কি সুরজিৎ এই এতগুলি অ্যাপ্লিকেশন কিসের একটু চেক করে নাও। ইট ফাইলটা এসছে এইটা না, ওটাতে তো এই যে পেপার বুক হয়েছে বলছে তো পেপার পেপার বুক আছে। এই অ্যাপ্লিকেশন গুলো কি এতগুলি নট টুডে করো, একটু চেক আপ করে নাও, অ্যাপ্লিকেশন কিছু না থাকলে আনিয়ে নাও। I think she appeared on the last occasion. I just not today করে রাখো, কালকে। Yes.
I appear for the plaintiff appellant, my lord. It is an assigned matter before my lord. Here, my lord, the ad interim injunction has been refused by the learned court, my lord. But the appellant is the one of the shareholders of the pro forma opposite party number company, my lord. But here, my lord, the opposite party number 1 and 2, who are the directors of the pro forma opposite party number company, my lord, are intending to transfer the amount amounting to rupees 1,72 US dollars to the opposite party number 3, my lord, out of the fund of the pro forma opposite party company, my lord, without having any decision of the board of directors, my lord.
Now, who are you?
My lord, I am one of the shareholders of the company.
Are you a member of the governing body?
No, I am a shareholder
So they are intending to transfer the share of the company.
Fund 1,72,000.
How can they do so? They are members of the.
They are the board of director, but they are the member, but without having any decision of the board of directors, my lord. They are intending to transfer the amount to the opposite pro forma opposite party company, my lord.
Who is the defendant number 4?
But opposite defendant number 4.
You are the plaintiff appellant.
But the plaintiff appellant. But
Who was the defendant?
but the company defendant opposite party.
So you say submits plaintiff is holding shares in the defendant company number 3 at the phase, which is 12.4 total stake of the company, and one by entering into an agreement with defendant number 4.
Different.
4.
But the company. But the
Company is 3, you said.
no. Opposite party number 3, but the to whom that amount has been sought to be transferred, my lord.
I see. So he's intending to send it to defendant number 4.
No, my lord. Defendant number 3, my lord. Defendant 4 is the company.
The order.
Yes, ma'am.
The order.
By enter
Learned lawyer for the plaintiff. Plaintiff is holding this many shares in the defendant company number 3, that is Polymet.
defendant 3 company Polymet.
At the which is 12.45% of the total stake of the company. And the defendant 1 and 2 by entering into an agreement with defendant number 4. Promise to pay without being authorized by the board of which company?
Board of, my lord, the 3, my lord. Polymet.
So they are trying to they are entering into an agreement with a promise to pay this amount.
This amount,
Where it is from the company's fund.
my lord, the amount, my lord, our company is, my lord, retail, my lord, the opposite pro forma defendant number 4, my lord. But out of this company, my lord, they are intending to transfer.
So a shareholder,
Share.
not a director
No.
of Polymet.
No.
You are similarly situated with Ajoy and Achilles.
But they are the directors.
They are the directors of Polymet.
Polymet. They are the directors of retail. They are the directors of retail.
They are directors of.
Retail, my lord, pro forma opposite party company, my lord.
If there are directors of Ford, that is retail,
My lord.
there's কি কল লিখি এখানে বসছে defendant 1 and 2 by entering into an agreement with defendant 4. How can that be?
That is incorrect. Incorrect. But the actual fact,
Agreement was entered into by 1 and 2 with whom?
with, my lord, the 3.
With 3.
Before, my lord, the NCLT and IBC proceedings was initiated by the opposite party number 3 against opposite party number 1 and 2, my lord. There was a, my lord, terms of settlement was filed by the opposite party number 1 and 2 and 3, my lord.
So why the company is not aggrieved?
Yeah.
If they are misappropriating the stake of the company,
But they are the directors, my lord. They are intending to transfer, my lord.
how many directors
Why
are
is there any document?
Shareholder.
No, they are going to transfer, going to promise any documents. So,
Where is that agreement you are taking?
where is the agreement? That part.
Paragraph 4, it appears 1 Green Valleys and 2 directors.
My lord, page 112, my lord.
2 are directors of Then what is green? Please explain to us the order first. We are confused. What is the order?
No, it is a complaint.
But the terms of settlement is entirely, my lord, annexed. My lord, page 108 is the terms of settlement.
Right?
108, my lord, terms of settlement.
On it, which
This
is an
is an application under section 9.
9 of the IBC, my lord.
There is an insolvency and bankruptcy code, section 9 application.
Yes, my lord. Here, my lord, these proceedings was,
How expert interim order is to be given? The interfact is required to be brought in.
but my lord, the next date has been fixed. But the next date has been fixed. Last date, it was taken up for consideration on 15 June, my lord. They did not appear, my lord, and the matter has been fixed on 28th August, my lord. By this time, if they transfer, my lord, only, my lord, from till the next date of hearing, my lord.
The appellant has assailed, the plaintiff appellant has assailed
The order number,
the order
but dated 2nd May 2020.
5 number 2 dated 2nd May 2023, passed by the learned judge in charge, 11th bench, City Civil Court, Calcutta, entitled suit number 816 of 2023. Now, the learned court below refused to grant any ex parte order of injunction as written. Ex parte interim order of injunction.
Adding interim order, expert interim.
At this time, no interim order can be ex parte interim order. Uh,
25th August.
The facts giving rise to this appeal include is that the plaintiff filed a suit for declaration and permanent injunction, meaning contending inter alia that the plaintiff owned 12.45% share in the pro forma dependent company. And from one reliable source, the plaintiff came to learn that an application under Section 9 of the Insolvency and Bankruptcy Code 2016, Bankruptcy Code 2016, read with Rule 6 of Insolvency and Bankruptcy Rule 9 2016, has been prepared before the learned National Company Law Tribunal by the defendant number 3
Against the pro forma defendant.
Against the pro forma defendant company.
In the midst thereof, paragraph 5.
In the midst thereof, the defendant numbers 1 and 2, being the director of the pro forma dependent company, having a total 0.76% share in the pro forma dependent company, has entered into a terms and settlement with the dependent number 3. And agreed to pay a sum of US dollar, 1,72,000.
Though they had no right to enter into such terms of settlement.
Enter into such terms of
Though they have right.
enter into
Such terms of settlement.
Hence, the plaintiff was constrained to institute the suit, paying for declaration that the said terms and settlement was null and void, and a degree of permanent injunction also sought for to restrain the defendant from giving effect to such terms and settlement. So, along with the plaintiff, one application under under Order 39 Rule 1 and 2 was also prepared.
Had been dismissed by the
And
in which the ad interim
in which the prayer for
ad interim order of
an interim order of
temporary injunction
temporary injunction was
refused. Was refused.
offered, but the court refused to pass some extractive order of injunction. So, agreed thereby, the appellant has preferred this appeal.
Order 39 আগের অর্ডারটা তুমি নিয়েছিলে?
আমার ইয়েতেও আছে।
অর্ডার 39 রুল 3 টা কোর্ট হবে, ওই জায়গাটা গ্যাপ রেখে দাও, তারপর এটা ডট 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 করে দাও, নেক্সট এটা যেটা বলছেন স্যার।
The defendant number 1 and 2 is allowed to give effect to such terms and terms of settlement. The plaintiff shall suffer irreversible loss or injury, and considering this aspect, the learned court below should have granted the extractive order of injunction.
ও মিস্টার সাবমিশন এটা।
Therefore, first আমি শুধু লিখে দিয়ে পেন ড্রাইভে পাঠিয়ে দেবো যে we find we are of the considered view that the plaintiff appellant has failed to make out a case to lead the court to pass extractive order of injunction. So, hence, we didn't find affirmative in the approach and decision of the court below. So, for the reason discussed above, that makes the judgment, the order include.
It is made clear that the observations made in this order.
My lord, only one thing, my lord, since it has been fixed on 25th August, it may be preponed, my lord. But injunction,
Make that
only one observation, my lord, injunction application, my lord, maybe otherwise, my lord.
The learned court below is directed to dispose of the petition as expeditiously as possible, without being influenced by any of the observations.
Without being influenced. Yes, next.
Served the learned senior counsel on behalf of the corporation. Lord, the appeal really, Lord, arises out of an order dated, Lord, 31st January 2023, which is at page 71. Lord, I am aggrieved principally because, my lords, although hearing notices were issued, my lord, hearing was supposed to be conducted, I had appeared, but my lord, the hearing did not take place. I was not allowed to place my case because the matter stood adjourned on several occasions. One of the days when I had asked for adjournment, my lord, on that day, an order was passed. My lord, I do not admit that an order was passed because your lordship will not find any reflection in the, my lord, writ petition which was originally filed. And your lordships will also find that the order was never communicated to me. So, my lord, my principal ground of challenge before your lordship, before, my lord, the learned single judge was number one, that, my lord, no copy of the order was ever made over to me. And number two, even assuming for the sake of argument that an order was passed, I was not allowed to participate in that. My lord, however, my lord, the learned judge has proceeded on the basis that an order has been passed. My lord, and I can show from the writ petition itself, my lord, that there is no order which has been passed. I was only saddled with the supplementary bills, my lord, which were, my lords, obviously issued to me, to which I had raised an objection. And your lordships will find at every stage I have objected to these supplementary bills which were raised upon me. My lord, may I only take your lordship straight away to the order, my lords? My lord, if your lordship has it, page 71.
Which is this? Then 23rd December 2011 was the order. The order which you challenged.
My lord, never received. My lord, no opportunity given.
2011 order.
Yes, my lord, I filed the writ petition in 2014. Thereafter, my lord, it was pending. I had in the meanwhile also filed a supplementary affidavit in 2015, bringing on record, my lord, your lordships are aware, Rule 9. My lord, yes.
On the basis of the alteration in annual valuation,
Yes.
your taxes be enhanced.
My lord, yes. And by, my lords, I'll tell your lordship, it was 7,340 in 1996.
Where you have stated, submitted before the court that it was not given to you?
My lord, what was not given? My lord, the order?
The order.
Yes, my lord, my grounds, if your lordship.
Forget about the grounds. Where is the order? Where do we find it in the order impugned that that was your submission?
My lord, that was the submission. My lord, my lord.
Mr. Please take us to the order.
Yes.
That where you have said so.
Yes, my lords.
Now, court has said that there is a provision for appeal. You
Yes.
can prefer appeal.
Lord, but my lord, the basis for coming to this conclusion, my lord, had to be that an order was furnished. My lord, my right to challenge the order will only arise under section 189 once an order is communicated to me. My lord, that is, my lord, in all fairness, not recorded in the order. My lord, the order proceeds on the basis that, my lord, the supplementary bills are the order.
Was 189.
Lord, I'm grateful. Yes. বইয়ের কপি আছে? Yes, lords, I'm sorry, my lords,
Hey, one copy will do.
Only one copy I have. But section 189, your lordship has. Lord, so my right accrues only once an order is furnished to me in accordance with Rule 9 of the building rules, of the municipal corporation taxation rules.
The appeal provision.
Lord, I have no qualms.
Against an order of under 81, the order of what is 188? Kind of.
My lord, the building rule, my lord, the taxation, Kolkata municipal taxation rules. Lord, your lordships will find a green, very small green flag. I have marked it, my lords. Lord, over there are the building rules, specifically Rule 9. And I've set it out in my supplementary affidavit, which is a part of this appeal, my lords. Lord, may I read Rule 9, my lords, with your lordship's leave? Lord, Rule 9, objections filed under section 186 or under subsection 2 of section 192 shall be entered in the register maintained in Form G. When an objection is determined and order is passed, the municipal corporate commissioner shall cause to be given or tendered or sent. Lord, kindly mark these words, Lord. Tendered or sent by hand or under registered post a copy of such order to the person filing the objection in Form H. The procedure, my lord, thereafter, my lords, I'm skipping over. My lord, kindly sees B. Queries and observations made and records, returns and explanations called for by the officer under so and so, together with the order passed. The date on which such order is passed shall be recorded in the sheet. My lord, that is, my lord, in compliance with 187. My lord, and my lords, I am also relying on F. My lord, kindly sees F, very important. The order passed shall be read out to the person appearing at the hearing, who shall put his signature.
And if you do not appear, how can that be?
My lord, I had appeared on all the occasions except one, where I was not, my lord, there, my lord, admittedly, and I had written to them also that I am unable to appear. And this, in spite of that, they passed the order. My lord, thereafter, I raised objections also that I was not given an opportunity of being.
When was your representation?
Yes, my lords. My lords, kindly has. My lord, firstly, my lord, may I take your lordships to page 38, my lords? My lord, that is prior to, my lord, that is immediate.
No copy was given to him.
The difficulty is this, my lord, the order was passed in 2011.
Yes, yes.
My lord, the normally when it is sent, now my land offenders.
Ascertain that if a copy has been, how can you
That's true. That's true, my lord. I tried to ascertain, my lord, that readily the file, the relevant file is not available. But the thing is this, my lord, 2014 he has come to the court.
Yes. After
and order was passed
But
in
within
2011.
3 years. Within 3 years. I'm sorry.
Not 3 years, my lord. The time to prepare an appeal is 45 days. Then, my lord, he ought to have come. If the order is not communicated to him, within the period of limitation, he has to come that I have been prevented from preparing an appeal. The order has not been served on me.
Limitation will start from the date of service, na? Or from the date of signature.
From the date of the order.
No,
That is, my lord, the
obligation is to give a copy under the rule. So
that's right. That's, my lord, the regarding service. But the thing is this: if it is put, my lord, in the statute, there are 45 days, my lord, to be taken into consideration for preparing an appeal. Therefore, 45 days, if it is a limitation period, my lord, then one has to come, my lord, before that date that I have not been served with a copy of the order. But he has been communicated a order. That is, my lord, he says, my lord, this is not the communication. I may accept it. Illogically,
communicated.
a communication, my lord, the quantum of the valuation. Quantum of the valuation has been communicated. That is at page, my lord, 40.
Page 40.
40.
No, that is in the receipt.
Lord, respectfully, my lord, that's the rate card.
That is the rate card, Mr.
The rate card, but it says there was what is the amount, my lord, the valuation has been decided.
He must get an avenue to challenge, Mr. Ghosh. He must get an avenue. Question of limitation will be considered by the tribunal. It is 45 days from the.
No, I'm submitting. No, I'm not on that. If somebody comes to the High Court, then he has to come within the period of limitation prescribed under the statute.
You have not preferred any appeal
Now,
against
I have not preferred an appeal, but I am submitting, my lord, when the limitation period is prescribed.
From the date of service, Mr. Ghosh. From the date of service of the order. As I am hearing you today, I have to give the judgment within 10 days. Then limitation will count.
As far as the appeal is concerned, even on the basis of that, my lord, primarily the appeal could be preferred under the rule, but my lord, subject to, of course, my lord, the submission of the order to the authority. Appeal could be preferred on this communication also.
No, how your tribunal will accept?
Because, my lord, because it is a valuation issue. The valuation, my lord, whatever the valuation is decided, then one has to say, my lord, why it is wrong.
Right.
Right? Because the rent is the method of deciding the annual valuation.
The order is given where he will go.
My lord, the thing is this, your lordship, of course, my lord, might put this question to me. But, my lord, that regard, I made an effort, my lord.
Officer to bring a copy.
Readily is not available the file. That is the difficulty. I understand, my lord, this is the situation. So let me make an effort, my lord, to get hold of the file.
Copy of the order.
I understand, my lord, this thing is this, my lord. I also inquired of that.
Lord,
that it is not readily available. That is the reasons why not it could not be even after the process of
Lord, very respectfully, my lords, I am, my lord, armed with decisions of this honorable
Be
court.
armed provided you have taken that point before the Transit single.
Yes, my lord,
Where is your
my lord, it's not in the order, it's there. My lord, it's part of my writ petition. My lord, it's part of my grounds.
Learned
My lord, it's
judge
not been,
proceeded on the
Yes.
basis that you have been given a copy.
yes, my lord, despite the fact that I had represented before the learned judge,
Where
my lord,
do we
I was
find
there.
that? Is
Lord,
that a
it's-
ground of
Lord,
appeal?
I had asked the learned judge to record this. Lord, this is my submission. Lord, I am
Then
making this
you
submission
go-
before your
go and
lordship.
File an application before the learned single judge.
Lord, it's not been recorded, my lord. My lord, that cannot, my lord, kindly seize my grounds.
You are going with a writ petition. Your
Yes.
primary ground is I do not have the
Yes.
copy of the order. How can I go and file an appeal?
Yes.
This is your
Yes.
grievance.
Yes,
That is the main grievance.
I'm,
And you are saying that I have said that to the learned court. Court did not record the same.
yes.
So that is a fit ground for review. You have to go to that court and say, kindly record this, my lord, and pass necessary
Lord,
order.
my lord, I do not want to be put in a, my lord, difficult.
Oh, that is what the Supreme Court says. Because we have not heard him. The judge concerned had heard him. Your contention is that, my lord, this has not gone down in the order. That will be your contention. You
Lord-
will not be challenging the single learned
Lord-
judge.
My lord, I appreciate, my lord, what is falling from your lordship, but
When you
my lord,
appreciate,
only
make
one
up
thing,
your mind.
my lord, kindly, just one thing, my lord, kindly hears me out. My lord, these proceedings are ex facie bad. My lord, that is, my lord, ex facie bad. My lord, judgments of the Honorable High Court, of our High Court, clearly stating if no order is passed, the entire proceedings are vitiated. My lord, not only that, my lord, my lord, I have those propositions.
Insist on that, we shall make appropriate observations. That this statement was made before the judge did not record it. You are leveling an allegation.
Lord, I am not. No allegations. Lord, if your lordship desires that I come back after filing a review petition, I shall do so. Lord, but kindly appreciate, Lord, the proceedings.
We are trying to help you.
Yes, I appreciate, Lord.
Order comes where problem goes. Paragraph 7. Paragraph 10. 2000, see, you are the changed valuation, you are paying the money since 2011. You come to the REIT court after 3 years.
Lord, within 3 years. Lord, and
So whatever.
3 years is not
Lord,
the
and
time.
3 years.
Exercise.
Lord, 3 years.
Ghosh, please ascertain whether you have the copy
Well,
and bring it to us.
make an effort. Let me make an effort, my lord, to ascertain, because I also inquired, my lord, on earlier occasion to them. They said, my lord, that it is not readily available. Then I will make an inquiry again.
Registered, na? Rule says that it has to be incorporated in the register.
That is, my lord, recorded in the inspection book. But the order, my lord, which was passed by the special officer building, my lord,
Mr. এর নামটা জিজ্ঞেস করুন। Mr.
Mr. Huck.
Mr. Huck. Heard Mr. Huck, learned advocate appearing for the appellants. Stop. Mr. Ghosh, learned advocate appearing for KMC, prays for an accommodation to avail necessary instruction. Stop. Please the matter for further consideration under the same heading on. Yes, when can you come?
yes, at least after fortnight, yes, to me.
আজকে কত তারিখ? 27 তারিখ। On 11th July. Yes.
I'm grateful, my friends.
পড়েছি সৌগত কেন লিখলো না আমি সেটাই Yes, Mr. Singhania, you told us that the scheme has been cancelled.
Yes.
Now kindly come to your supplementary affidavit, Mr. Singhania.
As soon as the 2016 scheme comes in, automatically the previous schemes are.
Kindly come to page 9 of your supplementary affidavit. Supplementary.
Now today's have a previous number here. Yes, correct. Ultimately, the PMY scheme is there. That scheme is.
We will ask your welfare commissioner. We will ask your welfare commissioner to scrutinize the records and to take up all follow-up steps. Because page 9. Because of page 9.
Yes, sir.
Page 9 says
Hmm.
preparation of a transition plan for conversion of RIHS with PMAI. Directed to see meeting on such and such issues near convergence. Now, action points for welfare commissioner. Welfare commissioner will examine the applications received.
Yes.
And he will part eligibility, he will segregate and he will forward it to the appropriate authority.
I mean, all the applications pending, which has not been approved for payment, have been forwarded to the state government, state authority, that BDO, district magistrate, and the state authority. I also
Mr.
submitted last time.
Singhania, what is your stand? Your stand was 2007 RIHS is not there.
Yes.
New scheme has come.
Yes.
Now thereafter, government now has come with the Prime Minister Rojgar, that PMAY scheme.
Yes.
So all the revised integrated housing schemes, whatever documents are there,
Yes.
all those has to be sent to the appropriate authority under PMAY. Then they will say without whether allotment is there. But how can this order be sustained? That it stands cancelled, nothing kindly come to the next page of your supplementary affidavit.
Yes, my lord.
That is
R2
25th
page.
September 2018.
Yes, my lord.
See,
understand
understand
is directed to
minutes
refer
of such and such regarding
to the
convergence.
Yeah.
In the lighter, it is requested not to issue new sanctions of first installment under RIS and send applications to the concerned blocks.
Yes.
So if this is the state of affairs, then how could your deputy commissioner has said everything cancelled, we will not forward anything finished?
So far the deputy, my lord, the applications have been sent. I submitted last occasion, my lord. There are other respondents, number 5, 6, 7, 8, 9. They have not appeared. Now through them, my lord, we receive the application. And if it is cancelled or not approved, then we send it back to them as soon as the new scheme comes in. Now when the 16 scheme came, then we have sent all the application to them back. Only they could have submitted it again only after giving the Aadhaar card and the bank account. Only that was there, but they did not. They did not, my lord. Only, my lord, you have to see one thing, my lord. They want 40,000, not 1,50,000. What was the reason, my lord? If practically, my lord, if you see, government was giving 40,000 in 2007 scheme.
You reject their claim, they are entitled to a rejection order.
No,
That
what I say, they could have applied in 16.
We will record that, Mr. Singhania.
But only because the Aadhaar card bank account is not there, and they don't want to open it. Or
You
yes,
say that in your order, we will ask the competent authority, the welfare commissioner, to consider and dispose of the pending application. Reject their case. At least they are entitled to a hearing from you.
now, my lord, hearing so far is concerned, my lord, we received 50,000 applications, 60,000 applications.
No,
Out of that, my lord, the fund is suppose a fund of 1 crore is allotted.
Why should you go on surmises, Mr.?
But
Moreover,
sir,
there was a
this was the condition, my lord.
no.
In
there
all these
was-
schemes,
where
all these
there-
schemes, my lord, this
there
was the
was
condition.
another judgment delivered by a coordinate bench.
Yes, my lord, that he said.
Medipur Jela Shromik Union.
Yes.
In that the competent authority has said, competent authority has been relegated the matter. And you appeared in that.
Yes, my lord, that is there, but
You said Aadhaar card is required, but that that
Aadhaar card can be dispensed if the bank account is there, my lord.
Bank account has,
Yes.
Aadhaar card has been dispensed with, but bank account will be there.
Because the bank account is open only with the Aadhaar card. So if they furnish a bank account, it will do.
Be compliant.
And they could have done it, they have not done. So that order,
How they will do it? Your advertisement was on to September 2016.
yes.
Earmarking a date of August 2016 that you apply. Is this the way the authorities proceed? Kindly come to the advertisement. How the advertisement was published? This advertisement was published on 11th September.
No, the Gazette is of August. Gazette is of August.
11th September 2016.
And you incorporate a date that 18th August you have to deposit your applications.
Not that, my lord. They could have applied a phrase under 2016 scheme just by adding 2 words, adding 2 documents.
Suppose they have not done.
They have not applied.
They have not.
So, my lord,
Do they become disentitled to be considered under PMAY?
No. They have to apply a phrase. My lord, they can apply now under PMAY scheme, just adding 2-3 words there.
Where is it ordered that we are cancelling your application since you have not given us Aadhaar card and particulars, bank particulars?
The 2007 Aadhaar card was not there. Bank
Very
account
good. That was
in
your
2007.
submission before us.
It was not there. It came in 2016 only. And that update side order, my lord, is there.
Ashok, the present appeal has been preferred, challenging an order dated 31st January
2017.
passed in a writ petition being WP number 1149W of 2017. Stop. Next para. Nolhati Thana Bidi, BEEDI, Shromik Union, bracket A, in short, the said union, along with its functionaries and members, preferred the writ petition challenging inter alia a memo dated 17th of October 2016, signed on 14 November 2016 by the Deputy Welfare Commissioner, bracket A, HQ, and stating inter alia that বলে ... ওটা পরে বসিয়ে দেব। এইটাই করে তুমি কার্তিককে পাঠাবে। আচ্ছা। The writ petition was, next para, dismissed by an order dated 31st January 2017, observing inter alia that, quote unquote, in such circumstances, the applications under the old scheme cannot be directed to be considered under the new scheme, as the parameters of considerations have shifted substantially, unquote. Mr. Mukherjee, learned advocate appearing for the writ petitioner's appellants, submits that though there was an observation in the memo dated 17th October 2016/14 November 2016, that no application under RIHS-2007 will be accepted / entertained, and that the applications already submitted earlier, pending for sanction, will be treated as cancelled. The self-same respondents had granted the benefits to BD workers, BEEDI, under RIHS 2007 in the district of Murshidabad, VDA memo dated 30th of January 2017. The authorities have thus acted in an arbitrary manner in refusing to extend the benefits of the RIHS 2007 to the members of the said union. According to Mr. Mukherjee, in the impugned memo, no reason whatsoever had been specified as to why the remaining applications under RIHS 2017 shall not be accepted, and as to how the applications already submitted earlier and pending for sanction can be treated as cancelled. Treated as cancelled, though under the RIHS 2016 there was no clause that RIHS 2007 will be treated as cancelled. According to Mr. Mukherjee, the argument as advanced on behalf of the appellants were not considered by the learned single judge, and without even calling for affidavits, the writ petition was dismissed. In aid of his arguments, Mr. Mukherjee has also placed reliance upon an unreported judgment dated 7th June 2018, passed by a coordinate bench of this court in the case of Purbo Medinipur Jela Biri Shromik Union and another versus State of West Bengal and others. Wherein the court inter alia observed that, bole quote unquote, bole ... রেখে দিন। Drawing our attention to the averments made in the affidavit in opposition and the supplementary affidavit filed on behalf of the respondent numbers 1 and 2, Mr. Singhania, learned advocate, appearing for the said respondent, submits that the members of the said union, who were found eligible to be considered under the RIHS 2007 were granted the benefits. Subsequent thereto, the new scheme being RIHS 2006 was introduced. For BD workers, allowing all BD workers, who had not been paid the first installment under RIHS 2007 to file fresh application under RIHS 2006. But the members of the said union did not avail such opportunity and did not submit fresh application along with the other documents and particulars as required under the 2016 scheme. The RIHS 2007 scheme was also cancelled by the authorities. Mr. Singhania further contends that in the month of September 2008, a decision has been taken towards convergence of RIHS with Pradhan Mantri Awas Yojana, bracketing in short PMAY, and the old schemes had been discontinued. In support of such contention, reliance has been placed upon a memoranda dated 25th September 2018 and 19th December 2018. 19th December. Mr. Singhania submits that no application filed under RIHS 7 are pending, and that by a repealing and amending Act of 2019, the BD Workers Welfare Fund Act of 1976 had already been repealed. And it was declared that the new sanction of the new sanction of first installment under RIHS shall not be issued any further. Next, in reply, Mr. Mukherjee denies and disputes the contention that RIHS 2007 was cancelled. He draws our attention to clause 13 of RIHS 2006, which states that thus the observation made in the memo dated 17th October 2016/14 November 2016 towards non-entertainment of the applications under RIHS 7 and cancellation of pending application is not sustainable in law. Hard delayed consideration. Next para, the memo dated 17th October 16/14 November 16 does not disclose any reason whatsoever as to why the application submitted under RIHS 7 and pending for sanction would be treated as cancelled. Stop. Such observation does not find support from the provisions of RIHS 2016, wherein it has been categorically stated. ... Stop. It is well settled that principle of interpretation. It is a well settled principle of interpretation that a beneficent scheme should be liberally construed. The reason behind such rule of interpretation is that the authority should not whittle down the object and purpose of the scheme. Stop. ... It appears from the next paragraph, from the memo dated 28th October 2018, annexed to the supplementary affidavit filed by the respondent numbers 1 and 2, that the competent authority had prepared a transition plan for convergence of RIHS with PMAY and had accordingly issued directions upon the welfare commissioners to examine all the applications received by them and to send the applications which are eligible for housing assistance under PMAY so that necessary follow-up steps can be taken. For the reasons discussed above, we are of the opinion that the members of the said union, who approached the competent authority under the RIHS 2007 cannot be denied consideration under the new PMAY scheme for getting the necessary benefits, more so when the said members have filed applications long back and they have a right to be considered under the PMAY scheme. Stop. Accordingly, the order impugned in the present appeal is set aside, and the welfare and cess commissioner,
Number 2, my lord, number 2. Respondent number 2, my lord.
Who is the deputy, Mr. Shingania?
The deputy welfare commissioner, they are said in the headquarters. Welfare commissioner is sitting in Delhi. They are the deputy welfare here.
Welfare commissioner is in
Headquarters Ministry of Labor Welfare Organization. I am also building here. Number 2, my lord. Respondent number 2.
Deputy welfare commissioner এখানে নেই।
That's number 2.
Say this welfare and cess commissioner's office is in Nizam Palace.
Yes, yes. Deputy, my lord. Number two, respondent number two, having office at Nizam Palace.
ওই ক্যান্সেল করেছিল।
সার্ভিশন করে একটা মেরে রেখে দিয়েছে। এখানে দেখো অ্যাডমিনিস্ট্রেটিভ অ্যাপ্রুভাল টু ওয়েলফেয়ার কমিশনার দিয়েছে।
Deputy Welfare Commissioner passed the cancellation order. Oh, ওই হচ্ছে
Who is
deputy.
the competent authority?
Lordship, the Deputy Welfare Commissioner headquarter.
Yeah.
This is Nizam Palace. Lordship, kindly come 113. The address is given.
You know that. Where is the office of welfare commissioner? Is it right?
No, here we have only one office at
Mr.
Nizam Place.
But the welfare and cess is the page 99.
Respondent number 1. This is welfare and cess. Yes, cess commissioner. This is Ministry of Labor Employment, Labor Welfare Organization, Office of the Welfare and Cess Commissioner.
Cess Commissioner, whether it will be assigned to deputy or is assistant.
Deputy, my lord, deputy welfare.
Consider.
Deputy welfare commissioner.
No, the competent authority under your scheme,
Yes.
under the memorandum of direction is upon welfare commissioners of the state. The
Yes.
scheme which you have annexed,
Yes. my lord.
আপনি যে স্কিমটা দিয়েছেন
Sent to the limited payment.
welfare as per.
Welfare Commission.
Welfare commission.
Mr. Singhania,
Yes.
kindly come to page 9, the
Yes.
transition plan.
Looking, my lord, yes.
See, under
There are three.
the
Yes, here the
welfare
list of the-
commissioners as per discharge.
Yes.
Now this welfare commissioner
Please
office
check with video.
is at Nizam Palace.
Yes. All the offices of labor commission in Nizam Palace. my lord. All the
We
offices.
direct because he is the competent authority under the, and because deputy is lower to him.
Yeah, deputy, naturally. So,
He will, consideration will be sent to deputy welfare. He will not do everything.
but he will be sending it. Yes.
Accordingly, the order is set as the welfare and cess commissioner.
Having officer করে দেবেন তো এটা বুঝতে পেরেছেন আচ্ছা দেখুন না সেকেন্ড এম টু
Lordship, respondent number 1 is the welfare commissioner. One.
One is the Union of India.
Service upon the welfare and cess commission.
of labor and employment.
The address should have been given at Delhi, my lord.
Yeah, service upon the welfare and cess commission.
Building, comma, 5th floor, Nizam Palace. আচ্ছা আবার 234/4 AGC Board Road, Kolkata, 20.
এই রিপ্রেজেন্টেশনটাও ওয়েলফেয়ার এন্ড সেস কমিশনার welfare accordingly is directed having office at such having office at is directed to consider and decide the pending applications of the members of the said union, including the representation dated 22nd of June to page 108. Dated 22nd of June 2016, submitted on behalf of the said union for disbursement of the benefits
এটা কে দিয়েছে কপি দিয়েছে চলে ঠিক
disbursement of the benefits. আমি সব সার্ভিস করতে বলবো, সার্ভিস করতে বলবো।
না ওকে কপি দিলে এই রিপ্রেজেন্টেশনটা ও করতে হবে
এই বলছি ইনক্লুডিং যা কন্টেন্ট
ফর ইনফরমেশন
কন্টেন্টসটা দেখবেন।
ব্রিফ এসছে আমার কাছে।
Stop. On behalf for disbursement of the benefits upon the to the eligible applicants, comma, upon granting an opportunity of hearing to the president or the secretary of the said union. The welfare and cess commissioner would be at liberty to call for the bank account details and other necessary particulars from the applicants, and the representative of the said union would also be at liberty to produce all necessary records at the time of hearing. Stop. Upon considering the appellant's claim, the welfare.
Kindly one note, my lord. Respondents 7 to 16, there are 16 respondents of the state authority.
We are not asking you.
No, your lordship, but in the sight of the service club, they are not appearing. He has filed the affidavit of service, 7 to 16.
We will record.
The records, kindly record it.
Upon considering the appellant's claim, and in the welfare and cess commissioner shall take all follow-up steps. To take all follow-up steps. So that the to enable the shall take all follow-up steps to enable the eligible members of the said union to avail the benefits. Stop. The above exercise shall be completed by the welfare and cess commissioner within a period of 12 weeks from the date of communication of this order, along with a copy of the representation dated 22nd June 2016. Mr. Mukherjee, you have to send this representation. That is at page 108 of the stay application. You have that, otherwise order will go.
No, representation with me, 106, 7, 8, all are.
No, you will place the representations.
Yes, lots of the 108, previous 106, 5, 105, all are the representation. 106.
Murshidabad.
No, 106, 107.
But what you are saying?
No, your organization
is Nolhati Thana.
Yes, Nolhati Thana 110.
107 and 6 out of Murshidabad.
110 is the my representation.
No, 110. Yes.
109.
Along
108 to 10.
Within 12 weeks from the date of communication, along with a copy of the representation dated 22nd June 2016. Huh? Yes, sir. Any other
application by documents assistant labor commissioner.
ওখানে মিস্টার সিংহানিয়ার আগে একটা দিয়ে দেবে। They have filed an opposition, Mr. Singhania, state.
In the lower
report.
court, we have not filed.
They have filed a report.
What report?
Before the single bench, we have not filed a position. We have not.
State has filed.
I found an supplementary affidavit of state.
Yes. State has filed a supplementary.
Yeah. আচ্ছা, ওখানে একটা প্যারা দিয়ে দেবে যে though none appeared on behalf of the state respondents.
She will extend all sorts of cooperation to welfare officer, welfare and assessments.
From 7 to 16 minutes, no one has appeared.
Achha, where did you give the applications?
Lordship, this learned advocate Mr. Somnath Naskar appeared. I have filed an affidavit of service.
Actually, in spite of service, no one appears on behalf of the state respondents. However, on behalf of the said respondents, a supplementary affidavit has been affirmed. 356, their state, na? 356. State annexing a copy of the memo dated 28th August 2018, copy of the memoranda dated 28th August 2018, 28th September 2018, and a notification dated 8th August 2019. কি বলছো কাকে? হ্যাঁ তোমাকে। আচ্ছা, ইউ হ্যাভ, ওইটা না এখানে বলেছে, সেই জন্য আমি ওটা বলেছি। পেজ কিছু কিছু অ্যাডমিনিস্ট্রেটিভ স্যাংশন দিয়েছে তো, এই যে দেখো পেজ 108 on behalf of the big to say few thousands such and such submitted there to Nolhali PTO for getting money for building their actual dispatch to Nizam Palace. Wide memo dated Ato. Next, later on Ato submitted was sent to Nizam Palace, Vide memo Ato. Next, at last 111 sent Vide memo Ato. Next, these have not yet received. এই জন্য বলে দিয়েছি। Assistant Labor Commissioner with the above observations and directions, the appeal and the connected application are disposed of. There shall, however, be no other rest of us urgency. Yes, next.
But I am for the appeal in this matter.
You are there. Delay how many days?
Well, that has been condoned.
Delay condoned.
Delay, better was dismissed for default, thereafter it has been restored.
This is it's a residuary matter.
My lord, Yes. this is
Residuary.
no, my lord, this is group 6, my lord.
The group 6.
This
how
is
can
group
I-
6, my lord.
Where from do we find group 6?
My lord, the labor matter.
এই জয়ন্ত বাবু,
ওটা দিয়েছো।
item number.
My lord, kindly comes to my lord, the impugned order, my lord.
ইউনিয়ন অফ
আরে,
ইন্ডিয়া, কিন্তু আপনি এখানে দিচ্ছেন ইউনিয়ন অফ ইন্ডিয়া আর এক গ্রুপ টিম।
Church versus Union of India. আর তুমি দিয়ে দিয়েছো ইউনিয়ন অফ ইন্ডিয়া ভার্সেস কি?
আমার মনে হচ্ছে এখানে সালের গন্ডগোল আছে বলে দেখুন
Where-
নাম্বারের
If it is a group 6 matter, we cannot take up.
নাম্বার আচ্ছা 474 20 ট্রেনে দিয়ে হাজির করেছে
My lord, the,
সতেরোটা আনোইনি।
না
the appellant sought for regularization in the and post of anti-malaria Loskar, my lord. The sought for
So it is group 6.
state, my lord. They are the labor in the defense department. That is not a labor matter. My lord, kindly comes to my lord the impugned order, my lord. Oh, file ka nahi na.
3 matter.
Group 3 or group
Actually,
6?
my lord, they are the casual laborer before the concern.
Mr. Das, see the
Read
presentation
petition.
form.
Presentation
Petition,
form
what
of
you have,
Yes, yes, yes.
if we pass an order, it will
petition.
be without jurisdiction.
Group 9.
Yes, yes.
Please check up from the presentation form. এটা বলেনি আমরা সেকশন 5 অ্যালাউ করে দিয়েছি। আর দেখো না রিট পিটিশনটা কোন গ্রুপের পড়া।
My lord, under group 9, my lord. My lord, that is under group 9. Although, my lord, in my humble opinion, my lord, that
Actually,
does not come within the
it is a
purview of group
transfer
9,
B,
my lord.
my lord.
It's not a group 9 matter, my lord.
No, no, no. It is a transfer.
My
It
lord.
is a transfer B, my lord. Earlier asked. It cannot be a group 9.
Cannot be, my lord.
Advocate on record was Jibon Horimonli.
Yes,
They are filed in group 9.
that is the matter was pending for 2017. No steps has been taken. Matter was dismissed for default. I filed restoration application.
My lord,
Yesterday,
page
thereafter.
193, my lord. That is the impugned order, my lord, which says, my lord, it might not be, my lord, group 6. It might be, my lord, group 6 matter, my lord.
But it was before whose bench, which
Justice Devang.
The impugned order was,
it was heard by a residuary bench.
my
And
lord,
his
that was hard,
lordship-
my lord.
And his lordship took it up.
At that time, you did not raise this point.
Mr. Basu was appear.
That amount to waiver.
Mr. Basu appear on that day.
না, এর কথা বলে। ও দেখেইনি।
Yeah, আমার
এটা ভাগ হয়েছে for administrative convenience, not for distribution or judicial. একটু সাবঅর্ডিনেট হয়ে গেল। এতদিন পরে বুঝেছো তুমি এতদিন বাদে বুঝেছো। কি করবো বলো, শুনবো কি শুনবো?
Malad, the order is also a order that any Malad, it's a wrong order. Kindly see Malad, the page 196, the last line I am reading, Malad.
What do you say? Do we hear or we release on joint prayer?
Malad can hear out the very old matter, Malad.
Malad, from the-
2017 matter.
Writ petition dismissed.
Petition group 9 এ file হয়েছে।
শোনারই দরকার ছিল। শুনি কি বলতে চাইছি।
Malad, page 97 from top. Page 197 from top. I am just reading Malad. My CAN application.
But
Yes.
we cannot release it now it is group 9.
Yes.
We have to say this has been wrongly filed. It was not pointed out because then the order of the learned single judge becomes without jurisdiction. But his lordship has treated it as a group 9 application and has proceeded. What can be done? Yes. Place the order.
Yes, Malad. Page 196, the last portion of this order.
কোথায় 196?
Page
Malad, my CAN application.
196.
Well, the stay application, my lord.
আচ্ছা, in this matter, it was hard on affidavit.
My lord, it was not.
It was hard on affidavit.
Well, the stay application was filed, my lord, after the delay was condoned, my lord. Liberty was given to the appellant for filing stay
The
application.
last occasion.
Because
when the
initially
matter
there
was-
was no stay application, my lord.
There is nothing, Mr. Das.
But Lordship, can you peruse the order?
I am just pointing out the order.
Regularization কোত্থেকে পাবে?
Well, there is a scheme. The scheme was there in the year of 1997.
Regularization prayer. I think
Out of 21, my lord, 4 were considered, my lord, because my lord, they served
Well, they themselves,
cut off period of 1990, my lord. After
That is it.
1990, my lord, they served
there is a division
they
bench
served
order.
anti-malady and loss score for 2 times, my lord. That is why, my lord, their case was considered. Out of 21, 4 case was considered and they have been regularized, my lord. 17th, my lord, the writ petitioner before your lordship, the appellants before your lordship, their case
Well, page
not been
73
considered,
of
my
my
lord.
CAN application.
What is the reason behind non-consideration?
Because, my lord, that was because, my lord, your lordship kindly comes to my lord,
আচ্ছা, let him place the
my
order.
lord, my lord,
then.
my lord.
Well, first of all, also can you see page 73 of my CAN application?
এখন ওসব কি হবে? Come to the order first.
Yes, order.
Yes.
The order, my lord, the internal page
What
3.
is their age now, Mr. Das?
Their age is, my lord. They are within,
60 years up.
no, my lord. They are within the age.
Many clients have contacted you, Mr. Das.
Well, they have contacted because after the case was dismissed for default,
They contacted.
Everybody
You are
has-
appearing for all the appellants.
yes. All that.
Acha, tell us, place the order, let us see what.
Yes, there are as many as 17 petitioners in the writ petition under Article 226 of the Constitution SLA writing dated June 18, 2007, by which the request for regulation has been denied by the
This
authorities.
is page 83. This 18 June 2007,
No,
order
this is
which you challenged.
the order which is under challenge 15 to 2017, passed by Justice Devanshu Basa.
Oh, na. In the writ petition, you challenged this order of 18th June.
Yes.
Is that at page 83?
Page 83.
My lord, that is that. The order of the learned single bench, my lord.
No. The order which
Order
was challenging.
challenging which the writ petition was prepared.
Yes.
My lord. My lord, firstly, my lord, way application was filed, my lord. The order of the way application is that
We'll see.
Where
Mr.
application.
Das, you are not ready.
Yes, I am ready, mother.
If you are ready, then
My
why you are
two-poll
not-
submission before your lordship, mother, they frame a scheme for regulation of this case. Matter was stabbed up to the division bench of this honorable court. The division bench presided over by Honorable Justice Girish Chandra Gupta has passed an order. In terms of the scheme, everybody should be considered for regularization. Taking into that benefit of judgment, they filed his application before this court. Now, when they have filed the writ petition before this court, department has said, we have no scheme. But the order which they have framed for regulation in respect of anti-malaria law score, it has been issued by the Minister of Defense from Delhi and directed all the zonal unit to consider the one-time concession in respect of regulation of their case. They did not consider. There are some orders passed by the division bench of our High Court to consider in terms of the scheme for regularization. But in respect of our cases, they did not consider at all. Nothing has been considered.
So
For
place the order, let us.
Yes.
Very good.
Where from we shall get the order dated June 18, 2007.
Yes, June 18, 2007.
Page 56.
Page 116
Page 116.
of my CAN application. June 2007.
It is not matching.
My CAN application was connected.
Page, this is page 115.
150.
Reference is made to the Honorable Kolkata High Court's order dated 16 February 2007. in respect of 462 of 2004. In terms of the order dated 16 February 2007, passed by the Honorable Division Bench of the Honorable High Court consisting of their lordships, the Honorable Justice G.C. Gupta and Honorable Justice Prosenjit Mondal, passed in WPCT number so-and-so. Your case was taken up for consideration in terms of policy dated 21/8/1997. After considering your case, the competent authority has found that you are not eligible for granting temporary status under the said policy for the following reason. You do not fulfill the eligibility criteria as provided in paragraph 4.1 of the policy dated 21/8/1997 since you have not worked for 165 days of work for offices, observing 6 days for 2 consecutive years. It has been found that you have worked only 183 days, that is, with effect from 15/5/1991 to 14/11/1991.
Meaning of this, you have not worked for 165 days of work for offices, observing 6 days for 2 consecutive.
This is totally an unreasonable order. We have worked more than a decade as a casual worker in the department.
What is this para 4.2 of the policy?
The policy I have enclosed, Madam, and you see. They have read upon 97 policy, but policy is actually, Madam, annexure P3 of the writ petition. Page 73, I think, Madam. 73, Madam. Petitionটা ঠিক আছে? 73.
You are showing reply to the.
Where is the scheme?
This scheme has been
Policy dated 25th
Fifth,
August 1997.
it would be, Madam. Yes.
Mr. Das, this way it will not go. You prepare a concise, this way we cannot handle.
But I have prepared a list of date. Can you see my canned application? Everything is there. The list of date, Lordship, can you see?
Unless you show us this document, how we will proceed?
But I am placing the scheme, Madam. The scheme is there in the writ petition, Madam.
As per policy for such and such, the fear for this writ petitioner was negative.
Yes.
So where is that policy number for such and such?
The policy,
1st
have-
August 1997.
এই stay application টা কোথায়?
Madam, the policy they have framed on 25th April 1996, page 73, annexure P3.
আমার stay application টা কোথায়? Stay application টা কোথায়?
মোটা পিটিশনটা দিন, এই মোটা বাঁশটা, এই ছোট A4 এর পিটিশনটা দিন, A4 সাইজের যে
Page 73 is part of some pleadings, not document.
Madam, this has been issued from the headquarter New Delhi. Headquarter New Delhi. এই পিটিশনটা
Page 73 is a part of the order dated 8th March 2004. Come to page 70. But where is the policy?
We are so fortunate to have a determination, Mr. Das.
I think
That advocates should speak.
Madam,
We are in such a
Actually-
fantastic determination that we
actually,
want the advocates, we drag down the advocates. They do not want to do the matter. We drag them. Please come, please come, please come. Now we pass sweet words in convincing, we ask the advocate. The advocate is not no contact with the client, why the advocate will come? Simple ratio. Like this matter, matter dismissed for default.
default.
An appeal was memo of memo was fine. And the advocate forgot. The clients did not consent. My advocate forgot, petition dismissed for
Yes.
default. Now they awake. Advocate
Yes.
says now they will have to come and say, harsh words will be told to me. If I will restoration. And we are a lenient bench. We are filed a discharge, all right, allowed. Come with you. Now, when it is coming to the matter, see, Mr. Das, you are also not prepared.
But this actually, I do not know. I filed a complete CAN application. In that application. But
You file it in group 6. or in
CAN number 3, Lordship, can you see? CAN number 3 ta nahi? CAN number 3 file aati nahi tha. CAN number 3 ta din. That is why I filed a complete CAN application disclosing all these things, Madam. 3 of 2023. Petition also.
Restoration application. So to dispose of হয়ে গেছে। ওয়াটার শিটটা বের করো না। ওয়াটার শিটটা বের করে দেখো না কোন অ্যাপ্লিকেশনটা ডিসপোজ অফ হয়েছে। না, না, এই তো অর্ডার দেখলাম। এটার অর্ডার শিটটা কোন ক্যানটা ডিসপোজ অফ হয়েছে।
Application for delay, my lord.
Can see the final name. It's a.
The restoration and my lord, the delay, my lord. Restoration application was no delay application was there, my lord.
Can I?
আচ্ছা, পাওয়া গেছে।
Mr. Das first place the order in.
Yes, I am. Lordship, kindly see the order of the landed single judge. Yes, madam. Page 193. 193.
Yes.
Yes. The order dated 15/2/2017. As many as 17 petitioners. 193, madam. As many as 17 petitioners in the writ petition under Article 226 of the Constitution asserted a writing dated June 18, 2007, by which the request for regularization has been denied by the authorities. Learned advocate appearing for the petitioner submit that the petitioners were part of the applicants in the original application moved before the Central and Tribunal, Calcutta, in way number so and so. Such proceedings were disposed of by an order dated March 8, 2004. Being aggrieved, the Union of India had approached this court by filing a writ petition being WPC number so and so. The division been disposed of the writ petition by an order dated February 17, 2007, directing the authorities to extend the benefit of the policy dated August 21, 1997 to the applicants in the original application based on merit within a period of 3 months from the date of communication of the order. Learned advocate for the petitioner submits that the respondent did not comply with such order. He says that a contempt petition being CPA number 76 of 2008 was filed and that such contempt petition was disposed of by an order dated August 26, 2014, directing that the applicants were at liberty to challenge those data by way of a writ petition if they were so advised in accordance with law. Learned advocate for the petitioner also submit that the respondent authorities are bound by the direction given by the order dated February 16, 2007, passed in WPCD number 462 of 2004. The petitioners were found to have the necessary eligibility criteria by the tribunal. The request for absorption therefore cannot be turned down as directed by the order dated February 16, 2007. He relies upon the decision reported in so and so, R. Unikishan and another versus B.K. so and so. and submit that the judicial orders can be enforced. He says that the writ petition is the appropriate method of enforcing the order passed by the division bench. The respondent authorities are represented. I have considered the rival contents and advance on behalf of the parties and the materials on record. As many as 21 petitioners have approached the Central Tribunal Calcutta bench, way number so and so, seeking absorption. The said proceedings were absorption. The said proceedings were disposed of by an order dated March 8, 2004.
Which proceedings?
That is the earlier proceedings, madam.
Against which you filed the CAT
The
application?
Union of India order passed by the landed tribunal challenging the same. The Union of India filed an application before the Honorable High Court.
March 8.
March 8, 2004. This order was passed by Honorable Justice Girish Chandra Gupta. Division bench.
Girish Gupta passed an order on 17th February 2007.
First page, second paragraph.
First page, second paragraph.
Yes, yes,
8 March is the tribunal order.
yes.
Yes, said proceedings were disposed of 8 March.
8 months.
Uh,
A direction was issued to the respondent authority to the effect that those who have done at least 2 terms after 1990, their names may be incorporated in the notional seniority list and they may be regularized against the available vacancies within 3 years. The respondent had prepared a writ petition before the High Court, being WPC number 462 of 2004. The order impugned of the tribunal was set aside. A phase direction was given. The respondent authorities were directed to extend the benefit of the policy dated August 21, 1997 to the applicant based on merit within a period of 3 months from the date of communication of the order. Since the respondent authority did not do so, within the time stipulated, a contempt petition was filed and the contempt petition was disposed of without any adverse order. It appeared that the respondent authorities considered the claims of the 21 applicants before the tribunal and had arrived at a finding that some of those applicants are not entitled to the relief. Such disgruntled applicants of the original application.
Now, how many persons have got regularization out of 21?
4 Malad.
4
have been given.
and 17 was not given. These are the 17 left out.
Yes, then the issue has to.
The issue as to the entertainment of the petitioners for relief was left at large by the division bench. Their lordships by the order dated February 16, 2007 directed the authority to extend the benefit of the policy dated August 21, 1997 based on merit. The impugned writing dated June 18, 2007 does not find the petitioners to have the merit to qualify under the specified policy dated August 21, 1997. No material, however, has been produced before the court to establish that the decision of the authorities is perverse. Reliance of the observation made by the tribunal is misplaced. The order of the tribunal was set aside by the order dated February 16, 2007 passed by the division bench. The division bench did not find any specific petitioner to be entered for regularization. Rather, it had directed the authorities to consider the case of the petitioners in terms of the specified policy. The authorities had done so. Such consideration has not been demonstrated to be perverse. There is one more aspect to the matter. The petitioner had initially approached the Central Tribunal for redressal. Today, the petitioner had come directly to the High Court for redressal for the same grievances. In my view, the High Court does not have jurisdiction to entertain the writ petition.
Right thing here.
I did. Then I am coming. In my view, the High Court does not have jurisdiction to entertain the writ petition. It is not a case of the tribunal does not have the jurisdiction to enforce the so-called violation of the order dated February 16, 2007. Be that as it may, the writ petition is not the enforcement of the order passed by the division bench. A contempt petition for such enforcement has since been disposed of by the division bench. It is in essence of the redressal of the case made out by the petitioner in relation to such order passed by the division bench and the refusal of the claim of the petitioner made by the respondent authorities. Now the sentence start. The tribunal is the appropriate forum for adjudication of such dispute. I have no problem in respect of that. Thereafter, Lordship can see. However, since I have already decided on merits, I am not inclined to dismiss the writ petition solely on the ground of lack of jurisdiction. Well, this thing, Malat, he is traveling. I give in respect of this portion of this order. Malat, if the learned judge thinks so, the High Court has got no jurisdiction to entertain this matter. Malat, your Lordship know there is a provision of the Administrative Tribunal Act. There are so many cases. The High Court has referred the matter to the tribunal as a TA, transfer application. Suppose in BSN and other things, sometime it was the jurisdiction before the High Court. Sometime after notification issued by the central government, the jurisdiction goes to the tribunal. Normally, High Court has sent all the petition as a TA matter before the tribunal. Since it was a writ petition, the learned trial judge ought to have sent the matter to the tribunal that this court has got no jurisdiction of this case, so I can't decide the matter. Now the last portion, it was all right. I had no grievance in respect of, but this portion is troubling. However, since I have already decided on merits, I am not inclined to give a writ petition solely on the ground of lack of jurisdiction. But if court thinks that this court has got no jurisdiction, the court cannot pass an order on merit. That is my submission, Malak. Yes.
Suppose, let us go back to the judgment. That
Yes.
it is the court of first instance.
Yes.
Tribunal will be the court of first instance. A High Court will be assessing the order of the tribunal.
Yes.
As a not as a superior forum, as a superior forum,
Yes.
Assess the order of the court of first instance. Now, can you say an order because writ petition was filed by you?
Somehow, Malak, somebody has given the advice.
You have invited the court.
Yes.
A writ petition was filed by you. Should have immediately upon realization withdrawn the writ petition and gone to the judge.
But that has not been done. I can't blame my learned colleagues.
Done, Mr. Das. How can you now take the plea?
But now, court has taken the pen that yes, this court has got no jurisdiction. After considering all these aspects, court has found that this court has got no jurisdiction. Then when the court has found itself that this court has got no jurisdiction, then court run a trial.
When the court has said that I have no jurisdiction, but since I have decided the matter on merits, no further interference is called.
But Malat, if any case, the court thinks that this court has got no jurisdiction, then court ought not to have passed any order on merit.
Invited the court.
It is a transfer wave.
Was non-compliance of the order of the division bench. Because your contempt application was dismissed. Court said that go and file a writ petition challenging.
Yes, that also.
That must have been there, that you would be at liberty to file a writ petition.
No, my lord, that was not there, my lord.
That was not there.
No, my lord, that was not there, my lord.
Order passed in contempt proceedings, contempt application.
My lord, kindly comes to page 190, my lord.
190.
No, my lord, I'm sorry, my lord. That was there, my lord. I'm sorry, my lord. Be open to the applicant to challenge those merits by way of writ petition, if they are so advised. That was page 190, my lord.
190. Disposed of over challenge by way of a writ petition.
If they are so advised, my lord, in accordance with law.
Now against this you preferred SLB.
That also, SAP also there.
By whom?
By Jumonori Malik has matter has said to the
Which order was challenged?
Appellant.
Huh?
By the appellant.
Because when
Yes.
the appellant went against the order of Justice Girish Gupta. The contempt was before the contempt was before the division bench. Now the division bench order was what?
Actually, this matter after the division bench order, they could have filed a fresh original application before the learned tribunal, taking the recourse, taking the liberty granted by the division bench. But without doing so, my lord, a writ petition was filed.
Justice Gupta in the division bench said that considered their claim based on merit.
Based on
So we can see whether it is how it is based on merit, how much they did.
yes, my lord.
Then you have to say that I will proceed.
Yes.
Proceeding for each.
Yes.
আমরা total করেছে 183
Girish Gupta are in more favor. Justice Girish Gupta has said that you have to follow the scheme and consider their case for you. But they did not follow the scheme. That is the main thing. The scheme is framed by the government of India. Those who are working as an anti-money law scholar, as a one-time measure, their case was directed for regularization. What they have done, only 4 candidates and 17 candidates are left, madam. Although they are working more than a decade.
The tribunal does not have jurisdiction to enforce the so-called orders. This has to go back there. This order cannot be sustained.
My lord is setting aside the order and my lord allow them to file the appropriate application before the
appropriate forum.
appropriate forum. My lord, before that, my lord, as it was fell down from your lordship, my lord, the scheme is at page 140, 145, the scheme by which the respondent
So-
document is declined to, my lord, I am not going into the merit.
To commit the same mistake.
The present appeal has been referred, challenging an order dated 5th of February 2017, passed by the learned single judge in the writ petition being WP number 10100W of 2015. The case has a checkered history. Stop. The petitioners to stroke appellant's hearing, along with others, preferred an original application before the Central Administrative Tribunal in Calcutta bench, being way number 937 of 2003. Where is that 8th March order? আমাদেরই
8 March order is there.
My lord, kindly comes to page 67, my lord.
the application, original application has been annexed.
Original application is not here.
Do you have the WP, do you have the original application, Mr. Das?
Original application.
What is the prayer in that application? Inter alia,
Yes.
praying for issue, stating inter alia.
আচ্ছা ক্যান্টিনটা কি? Oh,
Or page 67, pair has been quoted by the tribunal.
there is a delay in preparing this appeal. 1 day.
There are two defects, Mr. Das. Delay of 1 day in preferring the main application. At number, and the names of the respondents do not tally with the cost. ওই জায়গাটা বের করে ওনাকে দাও।
That I have gone to the Manama section. Yes, yes. I have gone to the Manama section. The Manama section has said, since there is no liberty granted by the appeal court, therefore unless you take the liberty, we can't allow you to correct.
What is the defect there?
Same in the proceedings of the into not. গুণী আর এখানে কি দিয়েছে জ্ঞান প্রধান নাকি what is the name of appellant number 8?
Narayan Chandra Das.
Eh?
Number 8.
You have written Goni Pradhan.
Here it is Bishwajit Banerjee.
দেখি জ্ঞান প্রধান
হ্যাঁ গণি প্রধান অ্যাপিলের নাম্বার 8 গণি প্রধান
আর 12 না
8.
Appellant number 8 to Bishwajit Banerjee.
Bishwajit Banerjee, my lord.
7 হচ্ছে গণি প্রধান।
এখানে 8 দিয়েছে
petitionerদের নাম নেই।
গণি প্রধান রিট পিটিশন নাম্বার
7 গণি প্রধান।
এখানে one thing, Mr. Das, file a 1-page application for the delay And we will give you liberty to correct the cause title here and now and pass the order. When can you come? We will keep it as to be mentioned and finish it.
One page application for
Because there is a delay. Unless there is a formal application, the appeal number will not be registered. Your computer slip will show otherwise.
yes.
We have to say that the defects have been removed. Because there is a 1 day delay.
1 day delay. All right. The order has been passed on February 2017. 15 February 2017.
15 February 2017.
Yes.
We have filed the appeal on 5th of April 2017.
After receipt of the certified copy. Certified copy to পাওয়া গেছে। Certified copy.
একদিনের ডিলে হচ্ছে কতদিন লিখতেছে
Can you come, Mr. Ghosh? Mr. Das?
My clients are in a remote place. They have to come for signature. Lordship, kindly fix it on 17 July.
We will again forget. We have
Oh, that is one. All right, Lordship, kindly fix on next.
not sending the file to the department. You file the application, give the number so that.
Yes. I give the number and I shall mention before your Lordship. That Lordship, kindly observe these things when I shall file it. Can I give liberty to file it?
Advocate appearing for the appellants to remove the defects as pointed out.
Yes.
We will send it down there. Go to the department, make the correction. Liberty is granted to the learned advocate on record of the appellants to remove the defects as pointed out in the report of the learned, in the report of the additional stamp report.
And also liberty to file the application for condonation of delay.
Remove the defects.
Remove the defect.
Mr. Das learned advocate appearing for the appellants praised for please for an accommodation to take necessary steps to remove the defects as pointed out in the report of the additional stamp report. Such prayer is allowed. List parties would be at liberty. Let the peacefully such prayer is allowed. So let the matter go out of the for the present liberty to next.